One memo. One memo. Give one
Your
memo.
Lordship.
Yes.
Your Lordship, I am from Bolangir, virtual High Court.
Go to one only, please.
Anticipatory.
Go to Kali Dev.
Lordship, pardon to mention item 17 of today's list. A fresh affidavit is being filed. Let it come.
No, let it reach. Let it reach.
তাহলে এইটা দিয়ে দিয়েছিলাম।
No.
না এটা আউট নেই জি।
হ্যাঁ নেই সেটা ফেলে দিন। এটা কি সময় নিয়ন্ত্রণ নেই জলদি কো তো
3175 of 24.
আগে
I pray for listing of the matter.
হ্যাঁ মেমো ফাইল করুন। মেমো ফাইল করুন।
Memo, online memo, I have already filed online memo.
কেতে নম্বর নম্বর কেতে কো তো
3175 year. 3175 of
3175 স্যার কেতে কইলে
75 of 24 year.
3175 of 2024 দেখো যদি অনলাইন মেমো হইছি তাকু মগাও হ্যাঁ অলরাইট
Today's list. Yes. Item 24 of today's list.
Yes.
Lasha, pay for 2 weeks time to
Let it reach. Yes.
I want to mention, my lord, there is RSA 79 2023 is
সেটা কি জোর কোন শুবনি
the RSA 79 by 2023.
Hey.
There is a fresh admission matter.
It will come. Yes.
Pardon to mention, my lord.
কোন
Pardon to make a mention, Your Lordship. RSA 28 of 2024. The execution proceeding has been initiated.
Yes.
Pardon to mention, my lord.
Who's mentioning? Yes.
Virtual court Sambalpur from your lordship. I have filed a mention memo today by number 3451.
3451 of 2000.
On
bail application.
On last date of order dated 6/4/23.
Is it a bail application?
Bail application number 14109, your lordship.
14109 of 2000
Of 2023, your lordship.
2023 yeah? Next day.
Your lordship, on last date of order on the
ছাড়ো মেনশন মেমো দেখিবা করিবা yes রাখো
Supplementary list item number 1 for judgment.
Thus viewed from any angle, the impugned order cannot be sustained in the eye of law. The writ petition is therefore allowed. The impugned order under Annexure 8 is hereby set aside.
Item number 2 for judgment.
For the foregoing reasons, therefore, this court finds no reason to interfere with the impugned order dated 21/11/2022. Resultantly, the writ petition is found to be devoid of merit and is therefore dismissed, but in the circumstances without any costs.
Item number 3 for judgment.
For the foregoing reasons, therefore, the writ petition is allowed. The impugned notice under Annexure 3 is hereby quashed. The opposite parties are directed to issue necessary orders of appointment in respect of the petitioners under their respective wards as per the selection list. The whole exercise should be completed within a period of 2 months from the date of production of certified copy of this order by the petitioners.
Item number 4 for judgment.
In the result, the bail applications are allowed. Let the petitioners be released on bail on such terms and conditions as the court below may deem fit and proper to impose, including the following conditions. They shall deposit their passports, if any, in the court below at the time of their release. They shall not leave the territorial jurisdiction of the court below without obtaining leave. They shall make themselves available as and when required by the IO. They shall appear before the court below on each date of posting of the case without seeking representation. The BL appeals are accordingly disposed of.
What's up?
Item number 5 for judgment.
For the foregoing reasons, therefore, I am inclined to allow the prayer for bail. The bail application is therefore allowed. Let the petitioner be released on such terms and conditions as the court below may deem fit and proper to impose, including the following conditions. The petitioner shall furnish property surety of the value of rupees 60 lakhs to the satisfaction of the court below. He shall not leave the territorial jurisdiction of the court in session over the matter without seeking leave. He shall deposit his passport, if any, in the court below. He shall make himself available as and when required by the IO.
My lord, this is the cryptocurrency matter. I'm sorry, my lords, I couldn't connect in time.
Yes.
Item 4, my lords, this is the item 4.
Yeah, item 4.
Yes, my lords.
Item 4, the bail application has been allowed.
Deeply obliged, my lord. Deeply. I'm sorry, my lords, I could not connect in time.
Yes, all right, yes, all right.
Item number 6, press submission.
Here, the defendant is the appellant. This is against a confirming judgment. Now the learned lower appellate court has dismissed on the ground of delay. There was a
On the ground of delay.
only
Yes.
on the ground of delay. Now it's 11 years, 4 months. There was a long delay. We had taken a plea that we had filed a suit to challenge the original order on wrong advice. So we had taken the plea of section 14 of the Limitation Act. That the learned lower appellate court at running page 18 holds that section 14 cannot be brought into an appeal. So that my lords would find at running page 18. And that would be I hope my lord finds that. Page 18, first para. Now it is to be examined whether the appellant can claim exclusion of time as per section 14 of the Limitation Act or not. And then ultimately the lower appellate court records that exclusion of time as per section 14 can be claimed only in original court. It cannot be claimed at the stage of appeal. Now this it's at page 20. So this conclusion of the lower appellate court is contrary to a series of Supreme Court judgments where they say that even if 14 may not directly apply, but the principles would apply while condoning an application under section 5. So that judgment I'm just giving a copy of. This is the first judgment, 2009 12 SCC 175, paragraphs 15 and 16.
Because it speaks of an application. Unlike section 5, I think there is some.
Let me kindly see paragraph 15 and 16, where they have said that the principles would apply. And this is not, several other judgments are there. We have got all of them. Nisha Bhattacharya, my lords.
Yeah, we'll admit it.
My lords. Para 16, they say that the principles would apply.
Let's see. Gautam Mishra, learned senior counsel with
Mr. Asim Das.
Mr. Asim Das, learned counsel for the appellants. Appellant or appellants? Is it one appellant?
Sole appellant.
Appellant. Peruse the impugned judgments. Considering the submissions and the ground raised in the memorandum of appeal, the appeal is admitted on the following substantial question of law. Whether the court below, whether the lower appellate court was correct, was committed an error in ignoring the settled position of law that exclusion of time as provided under section 14 of the Limitation Act can also be made applicable to appeals. Yes, this is the substantial question. You have framed some.
Yes, we have framed it at page 11.
I think whatever I've said is, I think it covers everything.
Then that 87 Supreme Court, if my lord wants, because delay only.
No, I'll say settled position of law.
My lord.
So I'll leave it open.
My lord.
So that you can, whatever judgments are there,
My lord.
issue notice to the sole respondent by registered post with AD, returnable within 4 weeks, requisites be filed within 3 working days. LCR be called for, list this matter.
The week commencing 8th July.
In the week commencing 8th July. Yes.
Great.
Item number 7.
All right, pass over.
Item number 8.
May please your lordship. My lord, the petitioner is a destitute lady. After being deserted by her husband, the opposite party number 2, the petitioner used to stay in the residence of her parents. While she was residing, she filed an application under section 12 of the DE Act Protection of Women from Domestic Violence Act with a prayer for residential reliefs, monetary reliefs, so on and so forth, my lord. Apart from filing this application, she had filed an application for interim maintenance under section 23 of the said act. On perusal of that petition, the Lord Court below was pleased to direct the opposite party number 2 to pay maintenance of rupees 3,000 in the year 2000.
Bolo.
2022. Your lordship kindly see the order dated 20th 9 2020.
No, you want the proceeding to be transferred from which court to which court?
My lord, why I submitting so, my lord? In spite of the order being passed by the Lord Court below, the opposite party is taking time on each and every date fixed. Therefore, this is the petition of the year 2019. This is 2024. My lord, I pray the case which is pending for adjudication in the court of civil judge senior division, Jharsuguda, particularly women's court, from that court to any other court under the jurisdiction of the district and session judge Jharsuguda.
Why?
My lord,
Why?
that court is not
Actually,
my lord, granting time on the application being made by her husband, my lord.
and this is a intra-district transfer. So you can approach the district judge. Why come to the High Court? It is the district judge who is competent to transfer a case.
My lord, in this
No, the
petition,
district judge can transfer. Why will you come to this court? I think section 24, okay, CPC, okay, district judge-
407.
No.
407.
It's a civil proceeding.
Criminal proceeding, my lord.
Criminal proceeding ହେଲେ ବି district judge କରିପାରିବେ.
District judge करते हैं.
district judge କରିପାରିବେ. ଆପଣ ସେୟା କରୁନାହାନ୍ତି? ଆପଣ district judge ପାଖରେ move କରୁନାହାନ୍ତି? Why will you come to the High Court? And your prayer is also something else. You want a direction for expeditious disposal.
My lord.
That also you can obtain. You can, for that you could have filed a writ application. Or even a CRLMC. If it is a criminal proceeding, then 482.
My prayer is twofold. One is for transfer, another for
Expeditious disposal.
my lord.
Transfer that without invoking the jurisdiction of the district judge, you have directly come, Mr. Proceed.
My lord, in that light, your lordship kindly dispose. of it.
I will not dispose. I will allow you to withdraw with liberty to move before the district.
My lord.
All right.
My lord.
In course of hearing, CRN Procedural learned counsel for the petitioner requests for permission to withdraw the transfer application with liberty to renew his prayer with liberty to approach the sessions court with such prayer. In such way, that permission is granted with liberty as aforesaid.
I don't know,
If
9.
you fail there, you may come.
My lord.
Yes.
My lord, next statement. Please taken up next statement.
Subhani, I get it.
Please taken up next statement.
You want an adjournment? Why?
My lord.
All right. Place this matter next week as per for.
I don't know, 10.
May I please approach? The petitioner has prayed for a direction to the
Mic that is Subhani, bond thing. Sound also. Yes, what is your prayer? What is this case?
petitioner has prayed for a direction to the opposite parties to accept his joining report. The petitioner, while working as serving as junior
What?
teacher, petitioner while serving as junior teacher, he was on leave from 16 to 2023 for his illness, and thereafter, after recovery, he submitted his joining report before the headmaster of the school, and the headmaster requested the BO to issue necessary instruction regarding his joining. And till date, the BO has not granted any.
Will dispose of.
Yes.
The petitioner, while working as a junior teacher in Gochaburi Government UP School, কোন জায়গা এটা?
স্যার এটা হচ্ছে গোছাবাড়ি খন্ডপড়া নয়াগড়
খন্ডপড়া?
লেখা আছে annexure 4 লেখা আছে পেজ নম্বর 18
না সেটা অলগা প্রকার গভর্নমেন্ট প্রজেক্ট অপার প্রাইমারি স্কুল হিজি
Gochaburi Government UP School.
আচ্ছা in as junior teacher in government project upper primary school
yes
comma Gochaburi
Government UP
comma
School.
Khondapada Nayagad was on leave from 16 to 2023 to 31/1/2024 because of health problems. He, after recovering, he submitted his joining report on 18/3/2024. Same was forwarded by the headmaster to the block education officer Khondapada, who had letter dated 18/3/2024, seeking permission. The permission কোন দরকার?
এটা যেহেতু শিক্ষা মানে status is that my junior teacher শিক্ষা সহায়ক they're not eligible to avail such type of leave. That is the reason the headmaster could not.
It's a long leave also, nearly 1 year, 11 months. It is the petitioner's grievance is that no action has been taken by the block education officer on the letter of the headmaster as yet. Considering the limited grievance of the petitioner, without expressing any opinion on the merits of the case, the writ application is disposed of, directing the block education officer Khondapada,
Opposite by 4 madam.
bracket opposite party number 4, to consider the letter dated 18/3/2024 of the headmaster seeking permission with regard to joining of the petitioner on duty, and to take a decision as early as possible, preferably within a period of 2 weeks
2 weeks.
from the date of production of certified copy of this order by the petitioner. Yes.
Published.
Item 11.
My lord, 11 is a Anganwadi matters.
Yes.
Annexure 4, my lord, kindly see. That is the advertisement I am challenging. That advertisement says, my lord, second line, ଏତ ଦ୍ୱାରା ସର୍ବସାଧାରଣଙ୍କ ଅବଗତି ନିମନ୍ତେ ଜଣାଇ ଦିଆଯାଉଛି ଯେ ସମନ୍ୱିତ ବିକାଶ ଯୋଜନା କାର୍ଯ୍ୟାଳୟ ଜଳେଶ୍ୱର ଅନ୍ତର୍ଗତ ଖାଲି ଥିବା ଜାମପୁର ମିନି I just want to draw your lordship's attention to that. This is a mini Anganwadi Kendra, Jamapur mini, and the present petition is a ST candidate, my lord, under annexure 1, and he wanted to participate in that, and she uploaded, but that was been rejected due to age, my lord, age factor, because he is now 39 years. And that advertisement page 11, my lord, kindly see clause 3, abedan formula niyamavali 3, ପ୍ରାର୍ଥିନୀଙ୍କ ବୟସ 1/1/2024 ସୁଦ୍ଧା 18 ରୁ 35 ବର୍ଷ ମଧ୍ୟରେ ହୋଇଥିବ. My lord, that's why that was been rejected, not accepted in digitally. So that's my lord, annexure 5 page 14, my lord, kindly see. That is the guideline for selection of mini Anganwadi workers.
Miss Mahapatra, new guideline has come.
This one is there. That is for general. After that, this is the new guideline.
No, 2023 is a good guideline. I said, I'm a guideline to work. Probably have not gone through. Probably have not gone through.
Mini by gone ache dekho.
Sabu setre.
My lord, that's why I'm saying ST. Even if that's there, my lord, SC ST will get 5 years.
Look at this. Look at this.
Say the point, Rishi.
Upon Mujan.
But I your lordship is saying I'm not.
No, you go through these guidelines. I'm saying you take time, go through these guidelines, and then make out your case. Because your case is entirely on the earlier guidelines.
Only.
Earlier guidelines. Earlier guidelines.
I was serving. I'm coming.
That's all right. That's all right. But you have referred to these guidelines. So what happened? You were engaged.
No, I was serving. I have disengaged. I have challenged this.
No, बुझ पाले नहीं. Advertisement वाला आपने
2010 I was serving.
अच्छा 2010. You are earlier. You were there.
There, I was serving. Then this is a new advertisement came in the COVID period. The petitioner conducting the case. I must have, my lord, not.
I could not get the facts. So you were working as
Anganwadi worker of that center.
That particular center.
Pet center.
So why did they issue advertisement then?
Because I was for some reasons I was not allowed to work, and there is a case pending before this honorable court. This court disposed of the case on 37/2023, non-appears for the petitioner. The counsel who was appearing for the petitioner didn't. Whatever I am told that he was no more there. So by in COVID period. So that was not brought to the knowledge of the petitioner. So that case was dismissed. When dismissed and it is communicated, the petitioner didn't know anything. When it is communicated to the authority, they press advertisement issued. So my submission only before if my guideline will fail, my lord, even if I am a SC/ST, I will get 5 years relaxation. That is the only case.
That is true. So you just go to, no, I'm calling it tomorrow. You go through this guidelines.
Yes.
Well, let's this matter tomorrow. I don't know whether these guidelines must be there.
No. My lord and senior knows, my lord, that SC/ST candidate will get 5 years.
No, I'm not on that at all.
ମୁଁ ଆପଣଙ୍କୁ WhatsApp ରେ share
Miss
କରିଦଉଛି
Mahapatra,
ଦେଖି ଦିଅନ୍ତୁ ସେ guideline
Miss Mahapatra, the guideline which you are relying upon is no longer there.
Yes.
So there is a new set of guidelines.
Okay.
Whether your case is covered under these new guidelines or not, you will have to find out. So I'm calling it tomorrow. Yes.
So tomorrow
I do not 12.
ମୁଁ ଇଏ ଦେଇଦେବି WhatsApp ରେ ଦେଇଦେବି
Yeah, please, Your Lordship. This is that Subarnarekha irrigation composite high school.
Yeah, argument ତ ହେଇଥିଲା ଆଉ କଣ?
Sorry ଥିଲା ସେଥିରେ ନମ୍ବରିଂ ଟା ଭୁଲ ଥିଲା ମାନେ amendment 17-18 ଜାଗାରେ 15-16 ହବ ସେଟା. That is the on the last occasion it was there, so that is why Your Lordship directed. So it is to be read as 15-16, not 17-18.
File a memo to that effect. Because while preparing for judgment,
हम file कर दे.
I'm closing it then.
Yes. The earlier judgment in OJC, Your Lordship may kindly also refer to that. Because that gave finality to the order of the learned tribunal.
नहीं, on Annex 14 it was the prisoner prayer is the initial scale up from the date of initial appointment 29/7/95, but they have given in 2005 from the date of judgment. Subsequently in the counter it has been modified from the date of the judgment of the tribunal 2002. So post was created in 94 and I was joined in 95. So why not from the date of initial appointment? That is my prayer.
For that, my prayer would be, Your Lordship may refer to the order passed in OJC 2977 of 2002.
Yes, what does it say?
That said, confirming the order of the learned tribunal, so far as the scale is concerned, there is no order passed. Fixation of scale.
All right. We'll close it, we'll see. Hearing concluded, judgment is out. Parties may file their note of submissions and memo of citations, if any, within 3 days.
I do know 13.
Pass over.
I do know 14.
Pass over.
I do know 15.
Your matter.
In this case, my lord, Your Lordship already had this matter, my lord, a number of times, my lord. The petitioner was appointed as an additional section teacher.
You wanted to file an affidavit?
Affidavit filed as per
Already filed?
noting, my lord. Noting in the list, my lord, that you already filed affidavit.
I have already filed an
Yes. Affidavit filed by the District Education Officer Puri. Yes.
There is absolutely no fault on the part of the petitioner, my lord, with regard to continuance in the school, my lord, because of the wrong order passed by the DO Puri, my lord. That is under challenge, my lord. The petitioner is deprived of getting his legitimate claim, my lord. Under Annex 8, that is the inform order, my lord. Despite of the inform order, earlier read petition, inform order was passed and direction was given to the opposite parties for giving the benefits to the petitioner. But despite of that, the DO Puri my lord, the inspector of school, the then my lord, passed contrary order to the order of this honorable court my lord. So I am placing the matter my lord, annexure 1. Lordship, for a moment, my lord, can I have a glance, my lord, page 10, which is the appointment order of the petitioner, that is of 1991, my lord. Thereafter, joining my lord, annexure 2. Annexure 3 is the resolution made by the governing body, managing committee of the school with regard to appointment, my lord. Annexure 4, your lordship, page 14, my lord. This is, my lord. So I herewith the necessary document of Sri Satulama, the BA appointed against sectional supra post for your approval. This is a, my lord, proposal submitted by the headmaster for the my lord, inspector of school, Puri, my lord, for approval of the appointment, my lord. Next page is the proposal, page 15, my lord. Then, my lord, the annexure 5, my lord, lordship can have a glance. The appointment was approved. Annexure 5, this is vital, my lord. Appointment was approved. The type copy also given, the legible copy not given, that is why the type, my lord, page 16, my lord. My lord, here, my lord, I am placing in pursuance of order number 5 dated 10/9/97, the Honorable High Court of Orissa, arising out of OJC number 3887 of 96, the Satulama, the BA section teacher Supra Gram Panchayat High School, Panti, is hereby approved with effect from 7/6/94 in the scale of a rupee such and such, with effect from 1/6/94 to 31/12/95. The scale of a 4,750. So, what's my the usual, despite of the approval of the appointment of the petitioner, my lord, he was not allowed the salary, my lord. The annexure 6 was passed, my lord. Annexure 6, my lord, page 17, my lord.
So it was withdrawn.
Withdrawn. That is just after a month, my lord. That was withdrawn, my lord. It was passed approval order on 18/5/99. This withdrawal order was passed on 36/99, my lord.
After 1.5 months.
Half months, my lord. That was withdrawn. And the being agreed by the same the petition of this honorable court. And this honorable court, my lord, already passed order, my lord. (9635), I have already given that order, my lord.
No, 9635.
My lord.
I have it.
In that case, my lord, that order of withdrawal was quashed by this honorable court, my lord.
Yes, let us read that order.
My lord.
In an earlier petition, the financial court passed order
that order was quashed. Direction was issued, my lord, to revive the last previous order.
So that was set aside. Then
that was set aside. Thereafter, my lord, under annexure 7, my lord, the Learned Advocate General, my lord, Odisha, my lord, by the annexure 7, page 18, wrote a letter to the inspector of school. Lord, we can have a glance, page 18, my lord.
Yes.
That you comply the order. Here, my lord, it was
thereafter
stated,
this annexure 8 has been passed.
It was passed, my lord. And
The
annexure
claim,
7 was issued.
the petition was appointed by the joint school after the appointment of the petitioner has not been made as per provision of Rule 5 of the aforesaid rule. He has gone to a different aspect altogether.
Different aspect, the details.
Yes, how do you justify this?
My lord, and that is why, my lord, we are directed to file an affidavit, my lord.
What is your affidavit? Let us see. This point could have been also raised before the writ court earlier.
Yes.
2 orders have been passed.
Yes.
It doesn't appear to have been raised. Now suddenly you come up with a different view. Again, constructive res judicata.
But my lord,
Clear case of constructive res judicata.
here's something which has been done illegally.
Maybe.
And that is
illegally, but not fraudulently.
No.
Fraud unravels everything. Had it been a case of fraud, yes, at any stage you raise it.
And my lord, with respect to the prayer in this case is, my lord, with respect to approval of the post.
No, no. Let us go to it. What have you, let us, okay,
Yes.
okay, let us see the prayer. What is the prayer? Why they should to approve the appointment? Yes,
To quash the
yes.
annexure 8 and to approve the post.
And why the impute order under annex 8 shall not be quashed?
Yes.
So, what is your reply? Let us see.
Yes.
Affidavit. I saw the white.
Yes. Well, it starts from para number 5 of my.
Yes, yes.
That
Can you
is
please?
humbly and respectfully submitted that in pursuant to order 10/9/1997. The Australian Inspector School, Police Circle passed an order. Passed an officer to write order 18/5/1999 that the post of the petitioner matter is hereby approved with effect on 7/6/1994 in the scale of the shown.
Yes.
With usual allowance and admissible under rules and physically joined again the vacant post of the headmaster in the said school with effect on the date he actually joined. He will draw his current salary, and these are the conditions, my lord, what it was there, my lord. But he is directed to acquire, my lord. That is most important, my lord. He is directed to acquire B.Ed qualification as per the rule in force within 2 years of the receipt of the order, failing which his approval will stand terminated. He will be paid his arrear salary on receipt of the post of the provision of the with the provision of the fund from the government in the said officer. There was specific instruction for the petition to acquire B.Ed qualification within 2 years from the receipt of the order, but the petition did not acquire the B.Ed qualification.
On that ground, you have not rejected. You have said his appointment is not
That
illegal.
is what it is required. That
You have not said that. You cannot develop your case, Mr. Patak.
no, my lord. I am permitted to read the next paras, my lord.
Yes.
Thereafter, my lord, the said school came into the granted fold with effect from 1/3/1986 and subsequently said education institution also taken over by with effect from 7/6/1994. Then, my lord, subsequently, the then inspector of the circle, police circle, withdrawn his other approval order 18/5/1999. That is what it was challenged, my lord, on section teacher. As the claim of the Mohanty did not come within the ratio of the judgment of OJC number 1012/97B as his date of appointment was later than that of Mohanty and in accordance with GO number 5/1991 by the officer dated 36/1999. Then, my lord, the petitioner filed another case in OJC number 9635 of 1999 before the Honorable Court prayed for approval of his appointment as additional section teacher in the said school. The Honorable Court Division Bench, while disposing the matter and set aside the withdrawal order dated 13/6/1999 and directed to restore the earlier officer order dated 18/5/1999. That is humbly submitted as in pursuant to the order dated 10/9/1997 in OJC case number 3887 of 1996 and the OJC number 9635 of 99. The Australian Inspector School Police Circle considered and rejected the claim of the petition for the approval of the post as additional section teacher of the said school on the ground that Sri Mohanty was appointed by the then managing committee and joined in the school on 19/4/1991 after 5/1/1991.
Why is that 5/1/91 date important?
My lord, there is a GO, my lord, government order, my lord. That is what we have referred in para number 7.
All right. Then,
on the date of issue of the said appointment order, the school was added educational institution in the school, and each appointment in the school is to be regulated under the provision of the Orissa Education Recruitment and Conditions of Service of Teachers and member of that rule of 1974, my lord. The appointment of Sri Mohanty has not been made as per the provision of Rule 5 of the aforesaid OE Rule 1974. As such, the claim of the petitioner has no merit for consideration and rejected. By the office order dated 20th April 2000 by the then Inspector School.
what is the meaning of the appointment was not made as per Rule 5?
My lord, Rule 5 stipulates, my lord.
Of the 74 rules?
Yes, my lord. 1974.
Rule 5 that has been now actually excluded. That has been deleted. It is no longer there, but at the relevant time it was there.
Yes.
Rule 5 ta ye bohre nahi. Ye bohre nahi puna bohre sutu.
I'll get that. But
Anyway, then
thereafter, my lord. Then, my lord, as the initial appointment of Sri Mohanty, the petitioner was not made as per the provision of Rule 5 of OE Rule and also in violation of the 5/1/1991, my lord. These are the
do we have that circular? Let us see. 5/1/1990.
5/1/1991.
And that also we don't have. Anyway.
Then, my lord, the next thing, my lord, what we have stated also, that the petitioner signed an attendance register, my lord, till 5/5/2000. Thereafter, he was not coming to the school since 5/5/2000, and after lapse of 7 years, the petitioner filed an instant writ petition before this honorable court. My lord. And we have accordingly, my lord, we have enclosed the copy of the attendance register also. My lord.
Take action against him. That is on a different point.
Yes.
If he has not come to the school, it is open to you to proceed against him. Can you not? But that is how is it relevant insofar as his approval, date of approval is concerned. This court, in the earlier writ application, where is that order?
My lord,
First writ application, Mr. Satpathy,
3887 of 96,
3887. That was filed by whom?
filed by the petitioner.
So why does he say that his case does not come within the ratio of this case? No, it is
That is
clearly
after
stated,
the-
agreed at the bar that this case is covered by the judgment of this court in OJC number 1012 of 1996, Vivekananda Das case.
Well,
And the subsequent order number 8 passed in this case. The reason for the
There,
reason
my lord, the case was decided on the basis of the ratio of the GO of 1991, my lord. Where we have distinguished, my lord, this petitioner is not covered under that one.
so that should have been said to the court. But an order has been passed. It has never been challenged also. The division bench order has not been challenged, or a review has not been filed saying that he is not covered.
Yes.
Now it stares at your face.
Yes.
How can you go beyond it now? It is no longer open. Once that order attains finality, it is never open to the authority to say that he is not covered by the issue. It is sitting in appeal over the judgment of the court.
That is the reason, my lord, your lordship wanted to get this particular information, not on verbal basis, but on affidavit basis. So that your lordship may dispose this case.
We today dispose of. Allow the appeal. Yes.
my lord, what happened, my lord, friend, my lord, submitted it for lordship, my lord. The scene up to 2000, my lord, the petition was continuing, my lord. This impound order was passed, my lord, in the year 2000, my lord. In the year 2000, my lord, thereafter petitioner, my lord, approved the learned tribunal. And a learned tribunal also, my lord, that was when the order was passed. Lordship can have a glance, my lord, Annexure 8, my lord.
Annexure 8.
Annexure 8, page 19, the impound order of this case, my lord.
Yes.
That was, my lord, passed on in the year 2000, my lord. And against which, my lord, the petitioner, my lord, upon the learned tribunal, he was not sitting idle, my lord. The learned tribunal, my lord, without entertaining the petitioner, my lord, referred the matter to this honorable court.
You refer the matter.
Permitted the petitioner to file writ petition before this honorable court.
How can the tribunal permit?
Because, my lord, the school was questioned, my lord, at the relevant time, was not taken over, my lord. Was not the cause of action arose, my lord, was not taken over, my lord.
Anyway, how is it relevant?
It was taken over in the
What
year
he,
1994.
my,
Even whatever they have said under Annexure A/3 that you have not attended the school, and that is a separate matter. They will consider. They will proceed against you if they so like, and that will be your defense. You may take up that defense. Why should
because
we?
of the fault on their part, my lord.
That is it. Why should
petitioner could not
Mr. Satpathy, you don't understand. Why should we go into that aspect? We are concerned only with Annexure 8.
My lord.
Correctness of the Annexure 8. That's all.
Well,
We
because
consider.
my lord, I am saying your lordship already passed order in number of cases. The Pastor Sarathi case, because of since there is no fault on the part of the petitioner, my lord, so he cannot be deprived of getting the legitimate benefits, my lord.
No,
Your lordship, a number of cases, your lordship passed order, my lord. Here also same thing, my lord. In the meantime, petitioner already retired from
Sir,
service.
what
my
is your prayer? Please
prayer,
come to
my
your prayer.
lord. The relevant petitioner was challenging that order after this honorable court, my lord.
So now that will be enlarged. How can the scope of the writ application be enlarged without you amending it? You have not amended it. You have not filed a separate writ application. It is open to you to file a separate writ application. But here you are concerned only with the order of approval.
If that will go, then all the benefits petition will
That's
be.
up to you.
Yes.
ଗୋଟେ କଥା prayer କରିବେ ଆଉ ଗୋଟେ କଥା କହିବେ.
Yes, lordship.
The petitioner has approached this court with the following prayer. The brief facts of the case are that the petitioner was appointed as assistant teacher in Kanti, na kon eta? Kanti Grama Panchayat High School.
Man.
Where is it?
Kanti Gram Panchayat
High School at Kanti in the district of Puri. Then it was in Puri probably. In the district of Puri on 17/4/1991 by the managing committee of the school. At the relevant time, the school was a aided educational institution within the meaning of section 2B of the Orissa Education Act. Section 3B of the Orissa Education Act. The petitioner joined in his duties on 22/4/1991. His services were approved by the then Inspector of Schools, Puri, by letter dated, by order dated,
Well, it is 18/5/1999.
18/5/1999.
99.
With effect from 7/6/1990. Subsequently, shortly thereafter, that is on 30/6/1999, or 98 lichidapon. Anyway, 99, the order of approval was withdrawn. On the ground that the claim of the petitioner does not come within the ratio of the judgment passed by this court in OJC number 1012/1997. Challenging such order, the petitioner approached this court in a writ application being OJC number 3887/1996. By order dated 10/9/1997, a division bench of this court took note of the concession at the bar. Taking note of the concession at the bar that the case is covered by the judgment passed in OJC number 1012/1996, disposed of on 27/6/1997, bracket Vivekananda Das versus State of Odisha, and subsequent order dated 3/9/1997 passed therein, held that under the relevant rules. Accordingly, the order dated 30/6/1998, 99 lekhaich 1999, see the ithe lekhaich 98. There is a wrong typographical error. 99 was quashed. Pursuant to such order, a communication was issued by the Office of the Advocate General, Odisha, to the Inspector of Schools, Puri, on 18/19/11/1999. With request to act accordingly. The Inspector of Schools, however, by office order dated 24/2000,
The two order was passed mail. That order skip of mailer, first order, first case mailer 3887. That was a mailer disposed of in accordance with the order of Vivekananda Das. Then mailer another, that was thereafter approval was made.
Okay, সেটা করে দেন, তারপর লিখুন তো, সেটা কাটি দেন। Rejected লিখলে by order. There is some confusion হয়ে গেল, ঠিক বোধ হয় আরো রিট পিটিশনটা এটা হইলো প্রথম তো পড়লে টিকে মূল পড়লো ঠিক না তারপর উপর পড়লো this court directed या পরে actually approval order হলো या पर approval order টা হলা 10/9/97. Pursuant to such order, the inspector of schools by order dated 18/5/1999 approved the appointment of the petitioner with effect from 7/6/1994 in the scale of pay of rupees 1360 hyphen rupees 2200 bracket from 1/6/94 to 31/12/95 bracket closes and rupees 4750 hyphen 7500 bracket from 1/1/1996 onwards with the usual allowances as admissible under rules. ऐसे दिखा लिखो तुम। Shortly thereafter, by office order dated 36/1999, the inspector of schools withdrew the order of approval on the ground that the claim of the petitioner does not come within the ratio of the judgment in OGC number 1012 of 1997, as his date of appointment is later than that of Sri Mahanti K.
My lord, Shatrughan petition.
No, it like as his date of appointment is later than that of Sri Mahanti. তার মানে বলতে সে বিবেকানন্দ দাসকে মিন করছে।
My lord.
In the date of his appointment, his পরে his পরে ব্র্যাকেট ভিতরে লেখো petitioner in OJC number 1012 by 97, Vivekananda Das is later than that of Sri Mahanti. Challenging such order, the petitioner again approached this court in OGC number 9635 of 1999. By order dated 28/10/1999, the division bench of this court held that the order dated 10/9/1997 passed in OGC number 3887 of 1996 had become final, whereby the inspector of schools was directed to approve the appointment of the petitioner with effect from 7/6/1994. It was held, on the face of that order, the inspector of schools clearly erred in passing the impugned order. Accordingly, the order dated 36/1999 was set aside, and the office order dated 18/5/1999 was restored. Stop. Pursuant to such, notwithstanding such order, the inspector of schools by office order dated 24/2000 held that the appointment of the petitioner has not been made as per Rule 5 of the Odisha Education recruitment and conditions of services of teachers and members of the staff of aided educational institutions, Rules 1974, and as such the claim of the petitioner has no merit and therefore was rejected. The petitioner has filed the presented application impugning the aforesaid order, copy of which has been enclosed as Annexure 8. Heard Sri Bansidhar Satpathy, learned counsel for the petitioner. The case of the opposite parties, as revealed from the affidavit filed by the district education officer, bracket OP number 3, is that the petitioner that in the earlier order of granting approval, the petitioner was directed to acquire BD qualification within 2 years. But he did not acquire such qualification. Further, the school came into granting aid fold with effect from 1/3/1986 and was taken over by the government with effect from 7/6/1994. The petitioner's case did not come within the ratio of the judgment passed in OJC number 1012 by 97 B batch. B mana batch 1997. The claim of the petitioner was rejected since he had been appointed by the then managing committee and had joined in the school on 19/4/1991. That is after 5/1/1991. As on the date of his appointment, the school was an aided educational institution. And therefore, the appointment is to be regulated by the 1974 rules. Particularly as per Rule 5 thereof. The petitioner's appointment was, however, not made in terms of said rules, for which his claim was rightly rejected. Para. Third, Sri Vansidhar Satpathy, learned counsel for the petitioner, and Sri S.N. Patnaik, learned AGA for the state. Para. Sri Satpathy would argue that after passing of the order by the division bench of this court in OJC number 9635 of 1999, which is in line with the earlier order, also passed by a division bench in OJC number 3887 of 1996, it is not open to the authorities to pass any order contrary to such directions, as it would tantamount to sitting in appeal over the order of this court. Stop. That apart, the orders passed by this court, the earlier orders passed by this court, had attained finality. The state had never raised the question of irregular appointment of the so-called irregular appointment of the petitioner in the earlier writ applications. And therefore, it is not permissible for it to do so on the face of the order passed by, on the face of the clear direction issued by this court to approve the appointment of the petitioner, and in quashing the order, withdrawing the order of approval of the petitioner. Stop. Sri Patnaik, on the other hand, would argue that the question of appointment goes to the root of the matter, inasmuch as if the same is found to be contrary to the rules, no subsequent order can validate the same. Sri Patnaik further submits that the petitioner was absent from school after court data ଆପଣ ଗୋଟେ କହୁଥିଲେ
5/5/2000 madam.
5/5/2000 by not coming to the school or signing in the attendance register. Para. I have considered the rival submissions and have also gone through the pleadings of the parties carefully. In the earlier writ application filed by the petitioner, that is OJC number 3887 of 1996, was disposed of by observing as follows. Para 2 ta quote karo.
Everything has been discussed.
Nothing was raised as regards the mode of appointment of the petitioner in this writ application. In the subsequent writ application filed by the petitioner, that is OJC number 9635 of 1999, the division bench of this court referred to the earlier order and quashed set aside the order withdrawing the approval granted by the inspector of schools. Significantly, no question was raised. No objection as to the appointment of the petitioner was raised by the state before the division bench, as the order dated 28/10/1999 is entirely silent in this regard. Thus, this court finds that after passing of the order by this court, the plea of appointment of the petitioner being contrary to the provisions of the 1974 rules was taken belatedly. The impute order was passed on 24/9/2000, whereas the petitioner joined on 19/4/1991. This implies the plea now taken by the state. Such a plea was taken by the state for the first time 9 years after joining of the petitioner in the school. Firstly, this plea was available to be raised in the earlier writ applications also, but as already stated, same was not done, same was not raised. So, it would therefore be impermissible to raise the plea at this belated stage. Since the orders passed by this court in the earlier writ applications have attained finality, in as much as same have not been challenged before the higher forum, there is no other option available for the state but to comply with the same. If, according to the state, the orders were passed without having regard to the mode of appointment of the mode of initial appointment of the petitioner. Stop. The same could also have been brought to the notice of this court, either by filing review application or by challenging the said order before the higher forum. Stop. Neither of the option was exercised. Thus, it is stated at the cost of repetition that the orders passed by this court having become final, it was not open to the inspector of schools to take a different plea to circumvent the order of this court. So it goes without saying that such an action cannot be countenanced in the law. Stop. The impugned order under Annex 8 is therefore rendered unsustainable and deserves interference. Para. For the foregoing reasons, therefore, the writ application is allowed. The impugned order dated 24/2000, 24/2000, passed by the Inspector of Schools, Puri, bracket Annex 8, is hereby quashed. As directed by this court in OJC number 9635 of 1999, the order dated, original order kind, 18/5/1999, passed by the inspector approving the services, approving the appointment of the petitioner, is hereby is restored. Stop. That's all. The consequential benefits, as are admissible to the petitioner in law, shall be released in his favor within a period of 2 months or 3 months? 3 months. 3 months. Yes.
Lordship, I mean, just to submit if Lordship, the judgment, Lordship, because of fault of the authority, my lord, the petition will not be declared.
Don't whether add kardo. How the page is you?
Okay. Oblige.
Item number 16. Achhi.
In this case, appears counter affidavit has been filed by the state, my lord.
Counter affidavit has been filed.
But my copy has not been served on petition, my lord.
Okay, counter to nahi, हाँ, counter file is.
They 24 तारीख को फाइल ही I'm also submitting a hard copy of it.
I'm reading the data counter which got filed on behalf of opposite party number 1, one by opposite party number 2. This the
hard copy.
No, it's a scan copy.
No, scan copy. Hard copy.
Scanning.
For the petitioner today received the counter, just now received the counter, and actually permitted to file the rejoinder against the.
Yeah, opposite party number key counter ta by.
But opposite party number 2, my lord.
2, CD2.
Alright. Copy of the counter filed by the opposite party number 2 is served upon learned counsel for the petitioner and.
I am for the petitioner.
Petitioner and you are for the
I was the petitioner is OP number 1.
You are OP number 1.
I mean, you are the OP number 1. OP number 1.
ନା ଆପଣଙ୍କର ବୋଧେ ଅନ୍ୟ କୋଉ କେସ୍ ରେ ବୋଧେ ରହି ଆସିଛି
ଶୁଣିଲ ତ ରିପିଟ୍ ଆପଣଙ୍କର
ହଁ private opposite party number 1 in court both learned counsel for the both of whom request for some time to file rejoinder is this matter 2012
but in the meantime my lord as per lordship direction a selection file a appeal file everything is available.
I will just pass that order. Learned State Council also submits that as directed the original files are ready for being produced before this court. The files be kept with the State Council. place this matter on.
Next week.
After vacation, Lordship, because Lordship, no, because Lordship, the.
ଆପଣଙ୍କ stay order ଟା ବୋଧେ ଆପଣଙ୍କ favor ଅଛି।
ସେଇଟା କଥା
ବାନ୍ଧି?
Because
ଆପଣଙ୍କ
there is some
stay order ଟା ଆପଣଙ୍କ favor ଅଛି।
No, I have applied the certified copy, some document Lordship. That document has not been attached.
2012
In one minute. Or document has not been annexed Lordship, the CDPO in counter appeal Lordship. I have got.
Yes.
May it please, my lord.
Yes.
This is the second time or second journey of the petitioner to this court. In the year 1999, that is September 1999, the petitioner was engaged for a limited period, that is 89 days, and you will
Engaged as?
junior clerk
Yes.
in a Institute of Hearing of the Handicapped School. Of course, he was a student of that school also. He is himself of that handicap. In 99, when he was appointed, and thereafter, after some time, continuing there, they made a requisition to the district employment officer. Then he came to this honorable court. And this honorable court only gave him a protection that he shall continue till a regular appointment is met. But even thereafter, they never took the step for making a regular recruitment. And his claim for regularization was also not considered. Since few others who were similarly situated and appointed, their services were regularized, then the petitioner approached this honorable court in 2013. And by then, he had already completed nearly or more than 13 years of service. And till date, my lord, he has been continuing. And for this reason that in 2022, while the writ application was pending, they said that this should be filled up by outsourcing agency. The petitioner has not applied. So apprehending that he may be terminated again, he also filed an interim application. This court said that he shall not, this order of 22 shall not be applicable to the petitioner, let him continue. And despite all these things that an interim order was passed in his favor, what has been said that he was allowed to continue with breaks in between various spells of appointment. And now, my lord, when the question of regularization comes and a person has completed more than 25 years of service, and by the time he had approached, then also he had served for 13 years. Then it is said in the counter two things, that first of all, that he is a contractual employee, that his appointment was for 89 days, and that it was with a stipulation that his services can be terminated at any time without any notice. So, having his eyes wide open, if he has accepted the appointment, then he will be bound by those terms of appointment. And the second thing is that he has continued by virtue of the orders of the court. So therefore, the question of regularization may not be attracted. Well, to that, my submission would be that if a person has been continuing, even if on a temporary status or a contractual period of 89 days with various spells in between gap, we also know that old judgment of this honorable court in that Ravinarayan Mishra's case, which had gone to the apex court, that this is one of the pernicious system of appointment itself to give somebody appointment for 89 days and then 1 or 2 days break and again you give him an appointment. And if somebody has continued in that post and it is of a perennial nature, having continued for such a long period, My lord, the question is that whether that is a temporary post or not. Because regular is,
Uma Devi takes care of all the, Uma Devi followed by ML Kesari.
and I am, the judgment I had cited, which is there on your lordship's record also. That's a judgment of the Bombay High Court delivered by Justice Lentil. My lord, there it was said that the mental of permanency is attached to the post. Justice Lentil has very beautifully worded that judgment. So I was tempted to cite when it was placed for admission. And thereafter several judgments and even the latest judgment which I could get, that is in decided on January 30th, 2024. That is in the case of Binod Kumar and others versus Union of India. And the other judgment, your lordship, that Brajaraj Nagar Workers Union versus MCL, this Honorable Court decided in a division bench that irrespective of the status of those workmen, that was under Industrial Disputes Act, there also the contractual appointment system was there. This Honorable Court in a division bench said that considering the nature of work involved and the continuance of the employees in the post for a longer period, it cannot be said that those were temporary posts. That judgment has also been recently upheld by the Apex Court. I had seen that. I'll try to find out in course of the day. I'll give that judgment a copy. This is the judgment of my lord. May straightway come to page 8. After considering the Uma Devi, as your lordship said.
Page 8.
Para 8 and page 8.
Yes.
In the light of the reasons recorded above, this court finds merit in the appellant's arguments and holds that their service conditions as evolved over time warrant a reclassification from temporary to regular status. It's only a reclassification of the status. The failure to recognize the substantive nature of their roles and their continuous service akin to permanent employees runs counter to the principles of equity, fairness, and the intent behind employment regulations. But at the distant date, an argument to the extent that service or the employment under the state will be on the realm of the contract, that should not be there at all. Because under the regulation and the constitutional guarantee, all that which has evolved in the passage of time, a employment under the state can never be said that as if it is a personal contract. That may be under the domestic employment for domestic service. If a person has continued for about now 25 years, my lord, where he will go?
No, but in several cases also the Supreme Court has held that irrespective of the number of years of employment, if the initial appointment is illegal or entry,
my lord,
then
illegality, my lord, as your lordship in the other case also said that if it is fraud, if it is illegal, but if it is a question of irregular appointment, and even the Supreme Court,
Mr. Das, you will have to base your case on that.
my lord.
That is why I pointed out Uma Devi at the very first.
Yes, my lord, yes.
Uma Devi followed by ML Kesari.
My lord.
ML Kesari even has got even a step further.
My lord.
The rigor of Uma Devi was watered down.
And this is also in Vikramnath's case. Justice Vikramnath also has distinguished also Uma Devi's judgment on that ground.
It has been watered down actually.
My lord.
That cutoff date thing has been watered down. Because the one-time exercise to be conducted by all the government establishments, there's a mandate.
My lord.
Find out. So whether that has been done or not, let us first hear them. Maharana, what is your stand? What is this organization? Why is the central government a party here?
Because it is a central.
Where were you working? Ali Yavar Jung National Institute for Hearing and
Bhubaneswar.
Bhubaneswar Institute ଅଛି?
Blind.
Blind
Hearing.
hearing, but
The blind school amar achi.
That is the blind school name.
Oh, which is in Unit 3 or that I think that's Satyanagar.
Yes, my lord, this I'll.
yes, that.
The school is in Satyanagar, but this is a training center for the teachers of the deaf.
They have giving training
Jala.
teachers.
There is a training institute.
This is training institute.
I was talking of the school. I don't know that the name is Ali Yavar Jung, National Institute for Hearing Handicap. Anyway, so it's a government of India.
Throughout India, there is several.
It's a government of India.
Government of India undertaking.
So what is your stand, Mr.
This one is the society under registration of the Society Act, independently operating, but approved by Ministry of that.
No, not only approved, must be funded by the Ministry.
Yes, yes, yes. But
poor employee, junior clerk, come typist working for the 25 years, the government of India will put up a fight. No, you,
because
please make your submission. I'm not stopping you. What you must consider? Gariba loko se 1000 taka darma pratham actually appointment order. You will draw a consolidated salary of rupees 1000. Then very interesting. The appointment letter starts very well. With reference to the representation dated so and so, you are hereby offered.
that is the case, madam. This
He's the
student of that organization, and after one seat temporarily vacant created, he applied as a associate professor. He requested I will continue to. And admittedly, madam, by submission, government India have nothing to do. It is a due to independent society. They have to give an appointment, and that in that respect, Union of India is nothing to do, madam. Though we are giving funds to operate for the is a benevolent society, and it is not the society which has been created any economical structure, madam. My humble submission itself, when he is entering the service, he is barred by his eligibility criteria to hold the post, madam.
How?
He is overage at that time when he would be given the contractual appointment. It is also admitted, you will also may kindly see para 7 of the writ application.
7, yes.
That the petitioner is abundant person also made an application in the prescribed manner. However, petitioner apprehended that in his case may not be considered since the maximum age limit as on 28/2/2001 for the post of lower division clerk has been stipulated as 28 years. In the aforesaid advertisement, while discharging his duty, the petitioner has crossed the prescribed upper age limit. Petitioner begged to state that unless the continued service of the petitioner, notwithstanding the artificial break is between the regular.
No, is there no relaxation of age in case of disabled candidates?
He is not the disabled candidate. He is a teacher, my lord. The person not necessarily he is disabled to.
No. But you said that he was a student of that school.
Student, he is a teacher. Take training in that school, man. It is not necessary that the teacher is supposed to be blind.
Okay. I get it. Then
his entry in the service, matter. You know, he very well know that he is not eligible, but in the temporary period, he has given appointment. And subsequently, only he has appointed continue on 31/8/2098 to 22/2001. You will also may kindly see my counter annexure A/1 page 18.
Yes.
This is the 2nd February 2001. That period of that extension, you will also see the last paragraph, last most one paragraph. Please note that this is the last and final extension of the contract appointment. After this, no contract appointment order will be issued.
Yes.
After this matter, we make advertisement, call for the employment exchange for regular advertisement for the selection as per the
yes
recruitment procedure rules of the organization, madam. At that juncture, madam, my learned senior has been mentioned, petitioner approached this Hon'Ble Court and pray for a regulation of this service. And while disposing his writ application, the court has not entertained so far as the prayer for regulation is concerned. However, I may be read out that order passed by this court, madam. I will also furnish that. That 18/6/2001, that is the OJC number 23770/2001. Had the land counsel for the petition apprehending the petitioner's service shall be terminated, he has approached this court. Admitted the petitioner was appointed as a junior clerk cum typist in the institution of the regional training center. An advertisement was issued inviting application for filling of the different post. The last date of receipt of the application was fixed to 28/2/2001. Learned counsel for the petition submitted that he has already applied for the said post along with the application for condoning of the age. After hearing the learned counsel the petition, I do not feel any useful purpose would be served by admitting this application. Accordingly, the same is disposed of with the direction that the application filed by the petitioner being appointed in the post of consider along with others on its own merit. It is made clear that if the petitioner is still continuing the post, his service shall not be terminated till the regular appointment is made in consonance with the advertisement on Annexure 4. Requisite of the communication of this order will file.
Then Mr. Das, this stares at you. This order stares at you.
My Lord, my submission, Your Lordship may kindly see that in 1999 I was appointed. In 2001, when they issued a requisition to the Employment Exchange for regular recruitment, I approached this Honorable Court. And Your Lordship, yes, my Lord, what I humbly say, my Lord, that by then hardly even 2 years was not there to my credit on that contractual side. And then a direction was made that so long as the recruitment is not met on the basis of advertisement, I shall be allowed to continue.
But there was no bar for regular appointment.
Yes, my Lord. I strictly, I will not deviate from that. Your Lordship may kindly read it in the line whatever has been stated.
Yes. Mr. Bharana has read out.
My Lord, in 2001, there was no bar for regular recruitment, as Your Lordship says. But we are in 2024.
That order still stands.
This order still stands. My Lord, still stands. But no regular appointment has been made in respect of that particular post, and I have been continuing. Despite this order passed in 2001, since 1999 up to 2024.
You're a very good lawyer, Mr. Das, no doubt about it.
No, Lord, I'm very poor.
I've been seeing you from my beginning, since the last 30 years, I've been seeing you. I cannot but admire your skills. Now you are coming at the latches. You're trying to take advantage of the latches, delay and latches.
No, it is not exactly the delay and latches.
You came in 2001. You came in 2001 when you had not completed, as you said, 2 years. Then a direction was issued that regular appointment, till regular appointment is made, you shall continue. For some reason, they did not. Who stopped you from making that regular appointment, sir?
Because
naturally, he'll take advantage and say that you allowed me to continue for 25 years. Though it will not be strictly a question of acquiescence. There can be no estoppel against law. So
not on question of law, my Lord.
No, but again, you take advantage of that law.
I'm not on law, my Lord. It is, as you will also find, that Apex Court also time and again saying equity.
Yes, that's
so far as the purpose of I am a diploma holder of
the is nothing but an equitable doctrine.
Lord, I am a diploma holder of that very institute. I have been working there as a clerk, junior clerk.
I'll ask you a question. If that order was passed in 2001, why were steps not taken for regular appointment?
What happened during the process of selection, let's come to the notice. Earlier, a writ application was filed by someone that I have avoided in my writ application. Questioning that post, that is the reason that has been.
That was in 76.
Not 76.
That was before 2001.
Before 2001, that come to the notice that this writ petition is still pending. That is the reason that has not
No,
been.
no, where have you said that in your counter? Let us see. Where have you explained? Why didn't you take any step in 2001? You allowed things to continue as such, and much water has flown down the bridge, as they say. 25, 24 years have gone by, or 23 years have gone by.
Paragraph 5, page 2.
Paragraph 5 of the
Paragraph 5 of their counter.
Sub judice in Indonesia being
Not
enforced.
sub judice.
One Sarathi Charan Sahu.
Yes, my lord. He has left it, the post.
The post which has been created for the interim package, when my client has been petitioner observed, that has been questioned in that interpretation. But that is come right subsequently. That's why that has been.
But how does it stop you from going forward with the regular appointment?
As I also there is no bar. You should have taken consult any legal advice to the.
I'll keep it parted. You next week you obtain instruction. Yes, you obtain instruction. If you have explained it, but you have not explained anything. This paragraph doesn't explain. Mr. Das has referred to this paragraph, but it doesn't explain the delay.
That has subsequently that has been referred.
You say that this is the last and final contract appointment, and after this, no contract appointment order will be issued.
Yes,
but then the court has granted him a relief, saying that he will continue till regular appointment.
It also be para 13 of my order.
Para 13. Yes.
Thus, with reply to para 5 of the petition is correct, or opposite party number 3 took steps to fill up the several posts in the RC Bhubaneswar and sent a requisition to the employment officer, District Employment Exchange Khorda, Bhubaneswar, to sponsor the name of eligible candidate and also invite application for public through an advertisement published in the daily newspaper. However, the necessary action, interview and other tests fill up the post of LDC would not be taken as the matter is sub judice since 96 due to the pendency of WPC number 2789 of 1996.
When was it disposed of? This matter, OJC?
That I'll be.
From there, your clock starts. Your clock starts ticking from that date, from the date of disposal of that case. Does it not? Because that is your stand. You say because of the matter was sub judice, we did not take any action. But it is no longer sub judice. All these years it was never sub judice. It has been disposed of since long. It must have been disposed of since long. All right, heard in part. Sri Marana Learned PGC shall apprise the court as to when the writ petition filed by Sarathi Charan Sahu, that is OJC number 2789 of 1996,
96.
was disposed of. Please, this matter, we'll take it up next week.
My lord.
Next week. Next week.
Item number 18.
Disposal.
Commission is that I'm repeating for.
Date of disposal within a fraction we are getting.
The judgment will take some time.
My lord. I know.
One has to.
ତାପରେ ବି ଅଛି submission line.
No, Mr. I understand. It will take 1 minute, but why should I?
Likely.
Why should I make that up? Why not? Let him say. He is the party.
And they also initiated a process. That is why they sent a letter to the Employment Exchange in 2001.
It is difficult. Let us see what best can be done.
Even otherwise, petitioner is not eligible.
That we will see what best can be done.
Right.
So humble submission is that I'm repenting for Utkal University. So my humble prayer and humble submission, I need 1 month time. A lot of documents are required. I informed through letter to provide all the documents which are kept with the previous lawyer. So give me a chance, I will submit all the document before the
last, if I remember on the last occasion also,
yes,
you had, no. The same argument that same submission that you are making. I'm reading out the previous order. Please wait. 23/4/2024. You are Mr. Tara Prasad Acharya, sir?
Yes, sir. Yes, sir.
Yes, I'm reading out the order. Please hear. Mr. Tara Prasad Acharya, Learned Counsel, appearing for the university, requests for a short adjournment on the ground that he has appeared recently and had sought for necessary instruction from the university.
Yes, sir.
So the same argument you are making today.
No, sir. So for 1 month, after 1 month, I will submit everything. I inform them to provide me all the documents.
It means they don't have any document.
No, only
No, absolutely not. I will not grant you 1 day time.
No,
I
please,
will not grant you 1 day time, sir.
So
Whatever
one-
is level of the pleadings, I'll dispose of this case. Yeah, 2014 matter, sir.
One thing is that in the writ petition, they mention about their EL according to their number of your working year 33 into 13. Then according to that, the EL is 300 and the 129 days EL is there. 120 EL is there. Already.
Please. Which is this university? Utkal University.
Utkal University.
Now,
Your Lordship,
it seems the university has absolutely no regard to this institution called the High Court of Orissa.
No, sir.
Absolutely no regard.
No, sir.
So I am not going to grant you 1 day time.
My humble submission is that, please, sir, just
No, sir. Last time you made a submission, I granted you time, passed an order.
I informed
Which
them.
I read out.
Okay, no, I already know about it. Give me, sir, a last chance. I'll submit all the documents sequentially, which help me and with the honorable court.
Why were those documents not produced for the last 10 years? This writ application has been pending for the last 10 years.
I informed them.
Maybe for the fault of this High Court. I will go to that extent of even
My
admitting.
submission is giving chance that there is a one later document was given to the government of Odisha to know what is the status related to the roster duty. So a lot of documents. Give me a chance, sir.
All right, I'll grant you 7 days time.
Okay, sir.
State also.
Yes. You are also directed to apprise the court with regard to the present status with reference to letter dated 19/2/2013 of the deputy registrar.
That is the main obstacle.
My lord, the annexure 2, my lord, with respect to that letter.
Annexure 2.
Yes,
Annexure
annexure
two.
to that letter.
Letter dated
Specifically
19/2/2023.
19/2/2013, that is that annexure 2. Your lordship's order dated 23rd April 2024, my lord.
Only after receipt of the decision of the government.
My
So
lord,
what happened?
I have also stated them, my lord. It is not required even to file a counter because it is the university is the only contesting party. At least they have to give me in affidavit what is the present status of the annexure 2 request made by the university. My lord, today even my lord in the morning hour, they have stated that, my lord, now they sort the file, they are in a position to resort the file and they need only 1 to 2 days time.
Let's take all right.
Time what your lordship now.
All right. I'll record that. Sri Tara Prasad Acharya, Learned Counsel appearing for the university, again requests for adjournment on the ground that he is in the process of collecting the relevant documents from the university and would produce the same for perusal of this court. So this court finds that on the last occasion also the matter was adjourned on the very same ground. Stop. This is a case of the year 2014. As such, 1 week time is granted to Sri Acharya to produce the documents as a last chance. Stop. Sri Rasan Patnaik, learned AGA, also requests for a short adjournment. Requests for a short adjournment to comply with the direction in order dated 23/4/2024. Stop. Place this matter next week. Stop. It is made clear that no further adjournment shall be granted under any circumstances. Stop. The parties are requested to come ready for hearing. Yes.
Item 19.
8th.
Okay.
8th.
Next Wednesday. Next week, next Wednesday.
Okay.
Yes.
The petitioners are acting as the lecturers in an aided educational institution. Milord, under the.
What is your prayer?
Milord?
What is your prayer? To antedate, step up antedation. The increment petition with that of Sunil Kumar Patnaik, that from Sunil Kumar drawing more pay. Yes. Yes, what are the facts?
Under the pay revision rule.
No, when did you join? Please tell me that.
Before my learned friend proceeds, there is a rejoinder affidavit filed by my learned friend that I don't find in my brief. If I can request my learned friend to.
I have served copy also.
You have served copy.
Yes, my lord, in rejoinder, I have only stated that under rule 9 of the 74 rules, the employees working in aided education institution are allowed to draw same pay and all the benefits as has been granted by to the government colleges. In the counter, they have stated that though in the resolution, it is.
But let them, Mr. Sharma, if you have filed a rejoinder, let them go through it. Let them go through it.
Today I will serve the copy.
Let a copy of the rejoinder filed by the petitioner be served upon C. A. R. Das, learned AGA. List this matter next week.
My lord.
Come ready.
I don't know, 20.
Item 20. Nobody's appearing. Oh, pass over.
Item 21.
Pass over.
21, my lord, this is a state's application.
Oh, state's application.
There, in fact, the claimant who is the petitioner in the arbitration, section 34 application before the Lord District Judge at Bhubaneswar. Now, the application TRP for transferring the case to Dhenkanal was pending. Now, in the meantime, there has been a settlement. She has agreed to an amount of 90,000. For that, there has been a memo filed seeking a direction from your lordship as to how the same be paid. If your lordship directs that it be paid at Bhubaneswar, end of the matter.
What do you say?
That 90,000 they are paid. 1 minute I will take. Kindly see the annexure 1 of the petition. Annexure 1, page 7, at page 21.
Yes.
Admittedly, the claimant has received 238,000 under the running will 1 to 9 without objection. Accordingly, proceed 5% bill amount to be deducted toward the security deposit from each running bills. Thus, an amount of 11,224.25 has been deducted from the 9 running bills, and the claimant is entitled to receive the said amount as contract has been closed without imposing penalty. Apart from the executive engineer, in his evidence has stated that as per 10th final bill, the executive engineer claimant is entitled to 7,220, and after adjusting the statutory deductions, he is entitled to 4,298. Apart from the said amount, the claimant is also entitled to earnest money amount of 5,000. The claimant is also entitled to 5%, 7,222, that is 361, deducting towards the security deposit as the work is already completed. Considering the evidence, both the oral and the documentary.
Why should we go to that? Why not to the order of this court, pursuant to which they have paid the amount? The order passed by Honorable Justice Satpathy, 1/2/2023.
Yes.
Yes, I don't have any, but they are not paying that amount.
No, see, in course of argument, Mr. General and Counsel appearing for the opposite party number 1 and 2 contended that the OP number 1 will not pursue her appeal, means you, which she has filed in arbitration application number 25 of 2016. If the state will pay her the awarded amount of 20,884 and the expenses incurred in the arbitration case amounting to 71,308. Mr. Jena also contended that OP number 1 will not claim any interest on the awarded amount, nor she will claim the fees and other expenses assessed at 75,000. If an amount of rupees 90,000 in total will be paid to her.
Yes.
A memo has been filed.
Let them pay here, my lord. I will issue the check.
Yes. All right. It is stated at the bar that the agreed amount of rupees 90,000 shall be paid by the state to the counsel for the opposite party in court. List this matter next week, or
Sir.
list this matter next week.
There is another TRP at instance of my.
So that will be automatically disposed of in terms of this. Disposal order pass kar.
Item 22.
Item number 19, next course rate instead of
All right. It will be done.
My lord.
Item 22.
My lord.
Yes, Mr. Mahathi, what is this?
In this case, the petitioner was appointed as a Jogan Soyago and he was issued with an.
Yoga Sohaka, I think Mr. Das appears.
Yes, yes, yes.
Mr. S.N. Das appears.
Solajananda Das.
Anyway, we cannot wait for him. He should be here. And who are you?
I am for the opposite six, my lord.
Private-
My lord, what I
Private opposite party.
Yes, I am opposite party six. My lord, in the meantime, opposite party Sarpanch has died. So Naib Sarpanch has appointed as a, so I may be permitted to time file counter, my lord.
Counter is necessary in this case.
Sarpanch counter.
Is a counter necessary?
Sarpanch counter is not necessary. Entire.
What happened? The collector must have removed you.
Yes.
You are disengaged.
Disengaged. Yes.
Disengaged by the collector.
Disengaged by the opposite party number 4 and
5 4 my lord.
On the order of the collector,
order of the collector.
Order of the collector.
We have taken the
Where is that order? Where is that order?
On order is
May kindly be accepted. That have been taken and the regions have been assigned.
If you want time, I can grant you some time. This is 2022, but if you are not ready.
In the meantime, the Sarpanch has died. That's
Maybe, but it's a case of,
I have nothing to.
it's a case of disengagement.
Yes, madam. Then
It's a case of disengagement. You have a copy of the counter?
my lord. I got the copy. My own limited prayer, my lord.
Leonard AGA files hard copy of the counter in court. The copy of which has copy of which has already been served upon the other side. Stop. The counter affidavit be kept on record. Yes.
My lord, admittedly, I have not been given an opportunity.
Let us see. Let us see.
My lord.
You are working as Jogan Sohaka.
Jogan Sahib. While working as Jogan Sahib, my lord, I have been instructed to maintain that temporary medical camp during the COVID, my lord. And was been instructed to expend from the PDS account to direction.
Where is that? Where is that?
Like,
is it on oral?
No. Annexed 1.
Annexed 1.
Page 10, my lord. ମୁଁ ଶ୍ରୀ ସଚେନ ସଚ ସରପଞ୍ଚ ଗତ କୋଭିଡ-19 ସମୟରେ ପ୍ରତ୍ୟେକ ଗ୍ରାମ ପଞ୍ଚାୟତର ଟିଏମସି ସେଣ୍ଟର ଖୋଲା ଯାଇଥିଲା। ଏହି ଟିଏମସି ସେଣ୍ଟର ମାନଙ୍କରେ କୋଭିଡ ଆକ୍ରାନ୍ତ ଲୋକ ଇତ୍ୟାଦି ଆବଶ୍ୟକ ସାମଗ୍ରୀ ରହୁଥିବାରୁ ଲାଷ୍ଟ 3-4 ଲାଇନ ମାଇଲ ଏହି ଦାୟିତ୍ୱ ମୁଁ ନିଜେ ସରପଞ୍ଚ ହିସାବରେ ଏବଂ ଗ୍ରାମ ପଞ୍ଚାୟତ ଦାୟିତ୍ୱରେ ଥିବା କାର୍ଯ୍ୟନିର୍ବାହୀ ଅଧିକାରୀ ସମସ୍ତ ଖର୍ଚ୍ଚ ପିଡିଏସ୍ ଆକାଉଣ୍ଟରୁ ବହନ କରିବା ପାଇଁ ଯୋଗାଣ ସହାୟକଙ୍କୁ ଦାୟିତ୍ୱ ଦେଇଥିଲୁ। ଶେଷରେ ବିଲ୍ ପଇଠ ପରେ ଟଙ୍କା ପ୍ରଦାନ ପାଇଁ ନିଷ୍ପତ୍ତି ନିଆଯାଇଥିଲା। ଏହା ମୁଁ ଲେଖିଦେଇଛି, ଦରକାର ବେଳେ କର୍ମରେ ଆସିବ।
This appears to be a self-serving document. କାରଣ କଣ ଏଇ ଡକୁମେଣ୍ଟ ତିଆରି କରିବାର? ଅଫିସ ଅର୍ଡର ହେଇଥାନ୍ତା ଗୋଟେ ଅଲଗା କଥା। ସରପଞ୍ଚ ତାଙ୍କ ଆଡୁ ଆସି ଲେଖିଦେବି, ମୁଁ ଏମିତି ଲେଖିଲି, ଦରକାର ପଡ଼ିଲେ କାମରେ ଆସିବ।
However,
dispute ହଉଛି, ସେଟା ବି dispute ହଉଛି।
ସେଟା ତ obviously dispute ହବ। ସେ ଲୋକ ବି ମରିଗଲା। ସେ ଲୋକ ବି ମରିଗଲାଣି।
ସେ କାଉଣ୍ଟରରେ କିଛି କହିନାହାନ୍ତି। ସେ
କାଉଣ୍ଟର ମୁଁ ତ ଏଟା
however,
you file a counter. Now I understand that.
After vacation, my lord.
No.
Because Sarpanch, I have to take.
Naib Sarpanch is enough.
Yes, Naib Sarpanch will give.
My case.
Anyway, let us see. If he says that he has not been heard, then
yes, ma'am.
That we will consider.
So-called notice was issued by the collector by the Annexure 3 at page 12, madam.
What is Annexure 2?
Annexure 2
by DD was
issued so-called notice. Pursuant to which collector has issued me a so-called notice. Annexure 3.
Then collector.
Madam. You are therefore called upon to submit your
reply.
I have submitted my reply.
Yes.
Submitted, no action has been taken. By the time I have deposited that amount, 2,90,000, I have deposited, which has been accepted by them. And also BDO has intimated the collector that amount has already been accepted. While the matter stood, the BDO has write a letter to the collector to take necessary action for disengagement. At page 17, Annexure 7. I would therefore, last one, necessary step may kindly be taken yearly against Chandrakanta Sahu for disengagement.
Then,
my lord, collector issued so-called notice. I have submitted my reply before the collector, but civil supply officer has directed the BDO to disengage me. It is at page 18, Annexure 8, my lord. Civil supply officer.
This is on a different ground. that you committed misbehavior and scolded with filthy language to the people as well as teachers during the time of distribution of smart
all
healthcare.
the allegations same so kaje dekho dita allegation ଅଛି
Misappropriation bhi ଅଛି.
misappropriation भी ଅଛି.
So what happened? Yes, Mr. Das, what is your stand in the counter?
That opportunity was given and all the allegations were examined. Thereafter, the order has been passed for investigation.
Para 9 ne seman କହିଛନ୍ତି. Page 5 second line. It is submitted the opposite part number 4 again by letter such as requested the collector Nuapada to take necessary step for disengagement of petition. It is submitted that after hearing the matter and after perusal of so-called reply as well as material available on record, it is found that the reply submitted by the petition was not satisfactory.
You were not personally heard. That is the only thing.
Hence, civil supply also directed to.
What is wrong in it?
Well,
what is wrong in it?
I have not given an opportunity of hearing. I have deposited the entire amount. I have filed my so-called that on that situation I have failed to deposit the money. And what is the situation arise when there is some quarrel between the teachers and me? Let them, the collector may consider my so-called my
All right, heard in part. List this matter. What a week per 15th May. If you want to file any counter, file it in the meantime. Yes. I'm just, I've made it heard in part. Yes.
Item 23.
23.
The man has retired since 2006 and they have filed their affidavit in 20th December 23 to comply the order, to pay the interest part of the order of the installment.
Only, I was just going through the last order passed by the coordinate bench. It says that the contemner undertakes to pay the interest part to the petitioner, and in this regard, Mr. Mahapatra also submits that he will file an affidavit to that effect on by 22/12/2023. You have filed an affidavit.
Sir, affidavit December 23 file करते देबे बिली देना देबे
5%.
So on the rest part, it has already been disbursed. Only with respect to 5%, we had made a prayer matter to. We are calculating it, and we are going to payment. That was on in the month of December 2023. We do not have any latest instruction. Can it be taken next week, madam?
Next week, yes. As requested by Learned State Council, list this matter next week. On which date the State Council shall
file the compliance application.
File a compliance application. Yes, file a full compliance application.
Yes. May I pray, my lord? Item 20.
Yes.
That was urgent, my lord. You have taken up next week, my lord.
No, next week he will. Passover reach. We'll make it next week. Next week.
Item 24. Item 24, my lord. I have received counter, my lord, on 6/12/2023, my lord. I need some time for filing the matter.
6/12. Today we are in 1st May, so 5 months have already gone. How much more time do you require? All right. List this matter as prayed for. List this matter on after vacation. Okay.
26 June.
26 June. On 26 June, the regional order, if any, be filed in the meantime.
Item 25.
Hard copy in this case may be kept on record.
Yes. Learned AG, Learned AG files counter.
24.
The hard copy of the counter in court, then be kept on record. Yes.
Please, my lord. My lord, here, my limited prayer, my repentation is pending before the collector. My lord, let by annexure 7, let the collector to take a decision because I have been selected as a Sikha Sahib pursuant to the order passed by this honorable court. Also, the honorable court, they have given assurances we to give you appointment, but till then they have not given an appointment. Though there was a contempt proceeding, in contempt proceeding also liberal view taken by this honorable court granting 4 months time is to consider and to give her appointment. Till today they have not given appointment. Only my limited prayer, my representation is there.
31/8/2023. File annexation, let them collector to take it.
There is no Sikha Sahayak post now.
No, I have been selected since long.
हाँ जी बर्तमान था Sikha Sahayak आपने
But the
selected.
same post, I am also claiming the same post. I don't.
Let them consider.
Sir.
The petitioner is a retrenched non-formal education instructor. It is her grievance. It is his. It is her grievance that despite being retrenched since long, she has not been absorbed as Sikha Sahayaks as similarly situated persons. Juniors also. So it is submitted that upon abolition of the scheme of Sikha Sahayak, such persons have been absorbed as junior teachers contractual.
Sir.
It is seen that highlighting her grievance, the petitioner has submitted a representation addressed to the collector, Cuttack, on 31/8/2023. तादरे विभिन्न प्रकार करेक्शन भी हिची नहीं की हिच तो मुझे देखुची हो कौन लिखी दी विषय
Sorry.
No, sorry कहलो कौन से लिखी दी severely corrected नहीं की 31/8/2023. Said representation is said to be pending. Without expressing any opinion as to the merits of the claim of the petitioner, the writ application is disposed of, directing the collector Cuttack to consider the representation dated 31/8/2023 submitted by the petitioner, if not already disposed of, and to take a decision thereon in accordance with law within a period of 2 months from the date of production of certified copy of this.
Sir,
Item 26.
Notice. A postal tracking report indicates that notice on the opposite party was delivered on 24/4/2024. Stop. There is no appearance. In order to grant another opportunity to the opposite party to appear, let this matter on 15th May.
Item 27.
ये भूल मत दे ये पापा खोल लो बेटा भूल मत दे yes
interim order
to continue चलो
petitioner is working as a grammar. See, the grievance of petitioner is that
good no yes please.
The grievance of the petitioner is that there is unpaid salary has not paid to her from March 2010 to March 2012. Though she has made representation to the BDO under Annexure 5, and there is a continued certificate issued by the Sarpanch as best.
You are working as what?
Grammar Rozgar Sevak.
Yes, consider.
Yes.
The petitioner was working as Gram Rozgar Sevak under who Gram Panchayat?
Yeah, Guagadia Gram Panchayat.
Guagadia Gram Panchayat in the district of Bhadrak. Having been engaged on 17/1/2008. Stop. The continuity certificate was issued in his favor by the Sarpanch of the Gram Panchayat on 8/12/2013, indicating that she had rendered her duties since 17/1/2008 without any break. It is her grievance that despite working continuously, the salary of the petitioner has not been released
from March 2010 to
for the period from March 2010 to March 2012. Highlighting her grievance, she has approached the BDO Vasudepur by submitting a representation on 12/9/2023. Stop. It is submitted that no action has been taken on such representation.
ଆଗରୁ ଦେଇଥିଲା 2/4/12 ଦେଇଥିଲା।
The writ application is therefore disposed of, directing the BDO Vasudepur bracket opposite party number kete
3.
opposite party number 3 to consider the representation submitted by the petitioner, comma, if not already disposed of, and to take a decision thereon in accordance with law within a month from the date of production of certified copy of this order.
Item 28.
It is a appeal करना था. Last order कौन है इतने? Notice was issued, whether notice has been served or not. Office note कौन बोल? The name of Mr. Satrugana Das and Associates be deleted. Notice issued as per order dated. Office to indicate whether notice on the petitioner was served or not. Let's this matter tomorrow. Day after tomorrow.
Item 29.
Lord, I may be pardon, item 27, my name may be recorded. I don't.
27, SM Das AG. Well done. Yes. Item 29.
Yes.
Yes.
I am working as a Anganwadi worker since 16 years. One opposite party number 4, Jayanti Malik, filed a complaint that I put her signature in the check and withdraw the government money.
Oh, you were to take specific instructions about what the bank has said, that it was done as per resolution and correctly done under Annex 8.
Those banking transaction as alleged.
Yes.
If those were considered also by the collector, that your lordship wanted me to take instruction.
Whether the order dated death of the UCO Bank in Nilagiri branch was placed before the collector during hearing of the appeal.
Yes. I have sought for the detailed instructions if those materials were there before the collector, but I have not got the same.
Again, you have taken time, Mr. Das.
Yes, twice I had taken.
Yes. Sri Das, learned AGA, submits that necessary instructions have been sought for from the collector. But same has not been received as yet. When do you want?
A week after.
Let's this matter on 15th May. The previous order be complied with positively, failing which the matter shall be disposed of on available pleadings, on the basis of available pleadings. Yes.
15.
For modification of this.
Modification, he needs to file an IA.
IA.
Koi CRLA mein?
For condition, he has been transferred to Raulkela. So it is his prayer that territorial jurisdiction. Further, he shall not. Last line 7 part.
The territorial jurisdiction of the court without obtaining leave.
Yes.
So he obtain leave and leave.
The court. So he should take the leave of the court.
Yes, you can apply.
Or 317 may be filed.
317, I don't think will be allowed because of this order, but he can obtain leave.
Yes.
So let Mr.
can
Mahadik.
approach the
Mr. Das, let Mr. Mahadik come. He can counsel what say file question.
About some other matter in court number 50.
I will pass that order, don't worry.
So my presence may kindly note.
No, obviously, if it will be passed, I will modify it. I will grant him. Let him apply for leave.
Yes, ma'am.
Let me first hear Mr. Mahadik.
That's all.
Yes, pass over matters.
So item number 7.
Item 7.
Yes. I will granted to attend the report.
Yes, yes.
May please. Let the substituted plaintiffs in a suit.
But there is a noting that ST certificate was exemption of court fee.
देखिए दियो decree टा your lordship may kindly see the decree. Your lordship will get in page 70 50. 50.
Yes.
I have given the trial court decree, my lord.
Yes.
There your lordship will get in the second paragraph, my lord. The plaintiffs belong to scheduled tribe commune.
Plaintiffs belong to scheduled tribe commune as they are exempted from paying. Okay.
My lord. They were the
in view of the a specific mention in the impugned decree as regards the regarding the fact that the petitioner to the appellant. Appellant, sole appellant?
No, all the appellants.
Belong to the scheduled tribe community. And were exempted from paying the court fees, the office order, the defect as pointed out, we ignored. Yes.
Beloved, one Sona Majhi has plenty filed the suit seeking declaration that the registered deed of acknowledgement of adoption taken by different number 1 in February 89 is void bill. On the ground of fraud, Sona along with her husband, Sona Majhi and her husband, the different number 1 claimed to have taken a registered deed of acknowledgement of adoption that the different number 1 was duly adopted by them. So admittedly the Sona Majhi was a scheduled tribe lady Miller, illiterate lady. Her husband is also an illiterate person Miller. So the beneficiary, the burden lies always on the beneficiary to prove that they have understood the contents and the document was executed. So they filed this suit. The Sona Majhi, after the demise of her husband, filed a suit seeking declaration that that document was fraudulently obtained on the plea of taking signature in a power of attorney. The signatures were taken and this document was...
The lady has signed?
The LTA.
LTA.
LTA, both her husband and herself. Both are illiterate.
Pardhanashin?
Not scheduled tribe.
Scheduled tribe.
Scheduled tribe.
So, what is that decision? Karbuja Queer. Privy Council among that 64 Supreme Court?
37 Privy Council, 63 Supreme Court.
63 Supreme Court, right?
Millard.
Tarbuja Queer or something?
Right, Millard. It was placed into service also.
Yes.
The seeking declaration that the suit was contested by different number 1, Millard.
Who is defendant number 1?
Who is claiming to be the adopted son?
The beneficiary.
Beneficiary. Millard, the lady got an expiry decree.
But before that, Mr. Bhuya, what was the cause of action for the petition plaintiff to come to this court? Seeking nullity of the...
Millard, after the demise of her husband, this property was recorded in the name of her husband. So after the demise of her husband, the different number 1 filed a mutation application on the basis of that adoption, acknowledgement of adoption, and claimed to record his name in respect of the property. So it came to the knowledge of the lady. She contested the mutation case dismissed. So once it was brought to her notice that such a document is existing, she filed a suit seeking declaration.
She didn't file any mutation appeal?
He didn't prefer any mutation appeal. Since such a document, fraudulent document came to the knowledge of the Sona Majhi, she filed a suit seeking declaration and also the declaration of her right title interest over the sued property. It was the different number 1 didn't contested the same, and expiry decree was obtained by Sona Majhi. After her demise, an application under Order 9 Rule 13 was filed. So since Sona Majhi and her husband died issueless, the different number 1 claimed that I am their adopted son. The next reversion, since they are scheduled tribes governed under the old Hindu law. So the next reversioner came before the court and they substituted. So after their substitution, in the meantime, the matter of 913 application went to this Honorable Court in a form of second appeal. Ultimately, it was set for decision on merit. After our substitution, the present appellants were substituted. The different number 1 filed a counter claim, claiming that he is the next reversioner. He took the plea of adoption as well as reversioner. So both the plea are contradicted to each other, and he filed a counter claim. The suit and counter claim both were proceeded together. The counter claim was dismissed. Against that, he didn't prefer any appeal. We prefer the appeal. The Law and Trial Court, recording the conclusion, your Lordship may kindly turn to the court held that because they are stereotype person, they are governed under the old Hindu laws, and under the Hindu law, Article 485 stipulates that certain rituals are to be followed. But the learned court held that all the rituals need not be proved, but only a giving and taking.
No, but how is Hindu law applicable to them?
The tribes are governed under old Hindu law, that is.
Is it old Hindu law, right?
Old Hindu law.
Yes.
Miller, that is why Article 485 of Hindu law.
The mullahs.
Miller, that was taken into consideration by the court. And in 485, your lordship will see there are 4 conditions. Apart from giving and taking, a datta homa, etc., were necessary, that the law and code has referred, but held that only a portion is necessary, and recorded a conclusion that since I have held to, since there is a registered instrument and the presumption is in favor of the beneficiary. That was taking on that ground, the law and trial court held that the adoption was valid and declared him as the duly adopted son while dismissing his counterclaim. Challenging that, I preferred the appeal. The Learned Appellate Court held that, Lordship may kindly see the findings, how the both are contradictory, Millard. Lordship may kindly turn to page. Lordship may kindly, the original instrument was not produced, but the Learned Court held that the certified copy is sufficient. So Lordship may kindly turn to page trial court, page 32, Miller.
Page 32.
Miller. Paragraph 16.
That is the trial court judgment.
Trial court judgment. Consequently, this court has no hesitation to hold that there was actual giving and taking ceremony for adoption of defendant, and the defendant was residing with the deceased plaintiff and her husband as their adopted son. This is the conclusion regarding the factual matrix, but your lordship may kindly see paragraph 11. What was the Learned trial court quoted? The article 485.
Yes, that I have seen.
There are 4 conditions, but the Learned trial court held that other conditions are not necessary because they are tribes, Miller. Your lordship may kindly see paragraph 16. During course of argument, Learned counsel for the plaintiff submits that as per Article 487 of Mullah Principle of Hindu law, no datta homa has not been performed during adoption of the defendant. So even if giving and taking is accepted, the adoption cannot be considered as valid work. Such argument put forth on behalf of the plaintiff is misconceived and not at all tenable in the eye of law. It is settled principle of law that datta homa is not essential in the case of an adoption. Where from he got it, he has not divulged, Miller. That apart, Article 485(2) enshrines that the physical act of giving and receiving is essential to the validity of an adoption in every case. As to the other ceremonies, their performance is not necessary to the validity of an adoption. So this is the conclusion held, and subsequently your lordship may kindly see the other conclusion.
No, what was held by the appellate court?
Appellate court held that since adoption has been actual giving and taking ceremony has been proved, so the trial court is justified.
All right, we'll admit it. Was there substantial questions?
That your lordship will get it at page
14.
Miller.
One and two. Heard Sri Vivekananda Bhuyan Learned Counsel appearing for the appellants. Peruse the impugned judgments. Stop considering the submissions. And the grounds raised in the appeal, comma, the same is admitted on the following substantial questions of law. Page ye ko jaan tu, page 14. One or two? है ना? Issue notice to the sole respondent with this, sole respondent by registered post with AD, returnable within 4 weeks. The requisites be filed within 3 working days. Stop. Next, LCR be called for. Release this matter, July record. In the week commencing 8th July.
Miller, I have filed a miscase, Miller. On the basis of this finding, he is going to sell away the property. Therefore, I have filed an application for stay of operation of the judgment. Instead, your lordship may say that no alienation, no third party right.
It is submitted that it is submitted that taking advantage of the impugned decree, the respondent is attempting to alienate the property. Stop. Since the appeal has been, this appeal has been admitted on the substantial questions of law as mentioned above, this court is inclined to direct in the interim that there shall be no alienation of the sued property till the next date.
The lordship may say one set of, since your
No,
lordship.
sorry, notice as above, accept one set of process fees. आप ना कोई दिल भी से लिख दी था। कौन कौन अच्छा? 13 और 14. We'll take it up after recess. ଗୋଟେ ପାଞ୍ଚ ହେଲାଣି ଆମେ ସରିଯିବ ନାଇଁ ଆପଣ ସେପଟୁ ଛାଡ଼ି ଦିଅନ୍ତୁ ଆସନ୍ତୁ ଆପଣ ଆସନ୍ତୁ ଯେତେବେଳେ ଆସିବେ
ଆପଣଙ୍କର ଚାଲିବ କ୍ରିମିନାଲ
କ୍ରିମିନାଲ ମ୍ୟାଟର କେତେ ଅଛି ଅଳ୍ପ ଅଛି କେତେଟା ଅଛି କ୍ରିମିନାଲ କେତେ ଫ୍ରାଇଡେ କେତେ କଣ ଅଛି ଦେଖିଲ
ଏଇଟା ଛୋଟ ମ୍ୟାଟରଟା ଖାଲି ଏରିୟର୍ସ
ହଁ ଯେ there is no time otherwise I would have taken up
ଫ୍ରାଇଡେରେ ଯଦି ଆସିବେ
କାଲି କି କରିଦେବା
କାଲି
କାଲି ଫାଷ୍ଟ ଫେଉଡ ଆସେ ତ ଫାଷ୍ଟ ଓଭର ହେଇକି
Lordship, beg your pardon, Lordship.
passport 7
तुरंत please this matter item 13 टा को tomorrow करो
Lordship, item number 14, Lordship.
Item 14, yes.
For adjournment, Lordship. We have filed affidavits, Lordship.
You are for
Manus Chan, on behalf of Manus Chan, Lordship.
petitioner or the
Petitioner, Lordship.
what do you want?
Adjournment, Lordship. Kindly be taken tomorrow.
Tomorrow?
Any day, Lordship.
Tomorrow?
It's a case relating to selection of minimum already.
Minimum, huh?
9th May.
Please this matter 9th May as prayed for.
Yes.
Weekly passport 7. 5 to 2024, my lord directed to examination of witness number A and B. Planning trial court posted on 9/5. Lordship may adjourn this matter.
তাহলে এইটা খোলা হয়নি উইকলিটা খোলা হয়নি আপনি জাস্ট টেক আ মেনশন ask or if you are not there ask somebody to
So item 20
somebody
20 yes
Taken after launchment.
nobody is there
I am there. What is the name? Taken after launchment.
after recess all right after recess yes Mr. Manti your associate
condition order କରିବା ପାଇଁ ଫାଇଲ କରିଥିଲେ ସେ ରାଉରକେଲା ତାଙ୍କ ପୋଷ୍ଟିଂ ହେଇଛି ସୁନ୍ଦରଗଡ଼ ଦ କୋର୍ଟ 100 କିଲୋମିଟର ଆୱାର ଫ୍ରମ ଦ ସୁନ୍ଦରଗଡ଼ ଏଇ ଆସିକି ସେଟାକୁ
item 30 ନା
ହଁ ଏଇ appeal କରିବାକୁ ହେଇଛି ଏଟା ସେ in the meantime has already attended 20 dates.
It is submitted that the petitioner is presently posted at
କାଲି କି ଅଛି
no petitioner is posted now
ରାଉରକେଲା assistant
Raurkela,
society
which is about which is at a distance of nearly 100 kilometers from Sundargarh. As such, he seeks leave. No, he seeks modification of the order, directing him to appear before the trial court on each date of the posting of the case. So, considering the submission as above, the condition is modified to the extent that unless his physical presence is absolutely necessary, the petitioner need not physically appear before the trial court on each date of posting of the case. But Mr. Das, Sanjay Das thought that probably you want that this he shall not leave the territorial jurisdiction without obtaining leave. Say to ko apan kare option to.
ନାଇଁ ସେଇଟା ସେ ସୁନ୍ଦରଗଡ଼ ସେ ରାଉରକେଲାରେ
All right. ହେଲା इधर इसके दास for the vigilance लिखी दी थी. That's all. हाँ. गोटी रहला तो. गोटी.
order is annexure 8.
Annexure?
Annexure 8.
What is your prayer?
For passing of the annexure 8, wherein the service of petitioner Sikha has been terminated.
You were disengaged.
Disengaged.
All right. Annexure 8.
Annexure 8.
What been selected for the post of Shila?
Well, the brief fact of the case is that petitioner Sri Babaro Himika of Bakarugoda, who had been selected for the post of Sikha by the order number so and so for the recruitment 2010-11 by the contractual agreement executed in Himika and the collector Jilla Parishad. Being agreed by the said order of the disengagement, the petition has a preferred writ petition before the Honorable Court of Orissa by double page number 17,000 wherein the Honorable High Court had ordered dated 16/10/2015, considering the submission made by the petitioner has disposed the writ petition, it was the order of disengagement on the sole limited grounds, remaining matter the collector comes chief executive of Jilla Parishad Rayagada to take fresh decision in accordance with the law after providing an opportunity of being heard to the petitioner with reasonable period of preferably within 6 weeks from the date of receipt of the copy of the order. Accordingly, the petitioner has filed the certificate of the order of the Honorable Court High Court along with the petition 2/11/2015. Basing on the orders of the Honorable High Court in the above writ petition, this case has been initiated on 9/11/2015 and issue notice to petitioner to appear in the court on of the OP2 to collector comes executive officer Jilla Parishad on 26/11/2015 and on 8/12/2015 at 11 for hearing on the petition filed by him. Simultaneously, the BEO and ABO and other officials who had conducted the inquiry had submitted reports on which basis disengagement order has been issued to the petitioner, were also noticed for hearing. Besides, the DPC, RT, SA Rayagada were also heard in the case. The deposition of L. Lakshmanamurthy, ABO Rayagada and the petition were recorded on 8/12/2009 in presence of DPC, RT and SSA, which has been tagged with the case record to form a part of the case. On the date of hearing of the petition has deposed on oath that during allegation of 70 student engagement at Cotton Field, he was the Sikha in Matikona PS. He had told the parents to the said student to go to the festival in his own village Bakarugoda. He had told them to go to the festival during the school time also. He had not told the students to go for cotton plucking. It is pertinent to mention here that petitioner has been disengaged from the post of Sikha under the provisions of RT Act due to engage of 17 children of his school for plucking cotton from his own field for at least 3 days till they were rescued by the CWC on 12/1/2015. In his deposition, L. Lakshmanamurthy, ABO Rayagada stated that he was ABO while he inquired into the case of Babaro Himika. He inquired into the case as per the direction of BO on 13/11/2015. As per the inquiry, Babaro Himika was working in Matikona PUFs. He inquired from Babaro, who told that he had called 70 students to village Bakarugoda. During recording of the statements by the ABO, it transpired that Babaro had asked the student to ask their parents to meet him if they require work. Gone through the entire documents available on record, it transferred from the inquiry report dated at 13/1/2000 of the ABO Rayagada, submitted to BO Rayagada that Babaro Himika Sikha of Matikona PS had utilized 70 students of the school in his cotton field. As per the statement obtained by the ABO Rayagada in the presence of a CRCC dated 13/2015, item number 1, why your school students of 70 numbers in different classes were engaged in your cotton field? Reply: Mr. Babaro has informed that he neither asked the student to engage in his cotton plucking in the field nor brought them to his farm. Item number 2, if not informed to them why they had been to your cotton farm during the visit to the Child Welfare Committee, in the above facts, he stated that he never identified to his farm to these students, but invited them to their village festival named by Cattle Puja at Bakarugoda of his village. Then 2 days back, he informed to them to engage by their parents and aged members for plucking of cotton. Then he confessed his fault to inform to the parents through the students for the purpose. It is also verified from the attendance sheet of 17 students submitted by the ABO CRCC that these students reading within class 4 to 6 were remaining absent for several days within the period from 5/1/2015 to 13/1/2015. Pertinent to mention here that the cotton field of Babaro Himika is 7 km away from POS Matikona, and these students were rescued by the child line on 12/1/2015. from the field of Sri Himerica. Sir Himerica Sikhasako arranged the services of 17 children, 13 girls and 4 boys of his school and used them as laborers in the field for plucking cotton flowers. He managed to convince their poor innocent parents for this service and used to pay them the labor charges for 3 to 4 days. The children were taken to the field by auto rickshaw like daily laborers till they were rescued by the childline on Par 2015. Sir Himerica used to leave the school during the working hours to be with the children in the cotton field. Exploiting the poverty of the parents, Sri Himerica easily got the 7 children to work in his field for cheap labor. Thus, the act taken by the Sri Babara Himerica deliberately violates the right to education of the children, guaranteed to them under RT Act 2009, under which all the children in the age group of 6 to 14 are protected from exploitation and guaranteed a completion of education for 8 years. By this, he has also violated clause 11 of the term and condition of the contractual agreements executed in between him and collector, CO, Jila Parsa Rayawada. In view of the above, I am satisfied that in disengagement of Sri Babara Himerica, Sikhasago is justified, which requires no interference. The petition is therefore dismissed and disposed of accordingly. Send the exact of the order of the all concerned to follow up action. Inform the disposal of the
then
Honorable High Court of Orissa. Pronounce the order in open court.
Sure.
My lord, the counter affidavit filed that the entire action of the opposite party is based upon the inquiry report submitted by the child helpline. The child helpline, as per the, and they have produced the report that it has taken place on 13/1/2015. But in the order, they have stated that they have rescued child on 12/1/2015. But no notice has been issued, and the inquiry has been done in presence, and no headmaster of the school has not been interrogated.
Where is that inquiry report?
Inquiry report has been produced by the state my lord.
I call for the connected writ applications. Why? What are they?
In the last occasion, also directed to the state council.
What are those writ applications? You had already earlier also approached this court.
Approach this and without violating principle
Order
of without notice.
my lord, that is the compliance of the order of the court.
I'm sorry.
This impugned order, my lord, that is in terms
In
of
compliance of the earlier order to dispose of the appeal. All right. There are two writ petitions.
Another writ petition was initially appointed in 2006, my lord. Thereafter, they again appointed 2008.
It is remanded.
Yes, ma'am.
Then one was remand order, the other is this 1191 Sitakono, re-engagement order. What is that application?
That order I am going through.
The representation constituted. Shut up. So where is the report? The report of the CWC?
There is no report, my lord. Only a complaint was lodged. They have produced the same.
No, the collector refers to a report, na?
Where is that?
That is the report of the ABEO.
Then what
Now read, my lord.
Then what your counter says, my lord?
Will you be permitted to place the order once again, my lord? That the collector passed this particular order, my lord, basing upon the inquiry report submitted by the ABEO. And that report, my lord, at the time when the inquiry was conducted by the ABEO, at that particular point of time, the petitioner was also examined. His statement was recorded.
Where is that report?
Everything is available. The entire file is with me. Let us have flag it, madam. See, ସେଥିରେ ତଳ ଆଡୁ ବ୍ଲୁ କଲର ରୁ ଆରମ୍ଭ ହେଇଛି ସେ ଗୋଟିଏ ଫାଇଲ ସେମାନେ ମେଣ୍ଟେନ କରିଛନ୍ତି ଏଣ୍ଟା କେସ୍ ରେକର୍ଡ ରଖିଛନ୍ତି ସେ ତଳ ଆଡୁ ଯୋଉ ବ୍ଲୁ ବ୍ଲାକ ମାରିଛି ସେଇଠୁ ସାରା ତାରି ପଛ ପଛରୁ ସବୁ ତକ ଜିନିଷ
ଇନକ୍ୱାରି ରିପୋର୍ଟ
ଭେରି ନେକ୍ସଟ ପେଜ ଟା ହଉଛି ତାଙ୍କ ଷ୍ଟେଟମେଣ୍ଟ ଗୋଟେ ଡକ୍ୟୁମେଣ୍ଟ ର ଗୁଡାଏ କପି ଅଛି ପଛରେ ଲେଜିବୁଲ କପି ଗୁଡାଏ ଅଛି କିଛିଟା ଲେଜିବୁଲ କପି ନାହିଁ ସେମ୍ ଡକ୍ୟୁମେଣ୍ଟ ଲେଜିବୁଲ
Inquiry report is
Same thing which has been quoted by the collector.
yes
Annexure 28.
मतलब limited question madam
Annexure 4.
these are the admitted these are the students he was the Shikha Sahayak
Yes.
these are the students and he was the Shikha Sahayak मतलब during those working days instead of teaching the students these students were not available in the school. So considering for a moment, my lord, what the petitioner has submitted, he allowed the students to go to his village to participate in that festival for 2 days.
Next is the Pongal, my lord.
So for 2 days, my lord, and he has also admitted that I have committed a mistake to inform the parents to come to work this particular place through the students. And the dispute in this case is not a matter that without identification whether that particular property belongs to me or not, the collector reached to a conclusion that I was directing these 17 number students to work in my field. So my lord, whether it is his field or not, my lord, the extent of irregularity what he has committed, utilizing the tendered students, my lord, that aging for the students who are reading in class 4 to class 6, he is directing them to participate in that particular process of working in the field during the day hours, my lord, during the school hours even. And my lord, that has been taken care of, my lord, at every stage. It was first pointed out at the level of the CWC. Thereafter, my lord, a report was published and in all the medias, my lord, that was the news. Thereafter, my lord, on the basis of the petition filed by advocates, complaints were registered before the State Human Rights Commission, so also, my lord, National Human Rights Commission. Then reports were asked for. Then that inquiry was conducted, my lord. Immediately, my lord, the BEO directed the ABO to conduct an inquiry. So the ABO first took the evidence of the petitioner first. Thereafter, he took the evidences of others. And
Any parent of the child examined?
No. All have no.
They were rescued from the field. They were rescued. Their photos, everything has been reflected in all the newspapers, and it has been examined that they are the students. I mean, such a person, my lord, knowing it very well that he is in such a position that a contractual post, and he dared to venture in this.
That apart, this is a subsidiary
Yes, ma'am.
jurisdiction.
Yes, ma'am.
Now this is a finding of fact arrived at by the collector on the basis of a report, basis of an inquiry report. In that inquiry, you had participated.
Yes.
Now, unless you
My lord,
come forward with a case that the findings are perverse, please bear with it. Unless you come forward with a case definitely saying that the finding is perverse or against the weight of evidence, why should this court interfere? I had asked you this question on the last occasion also.
The last one I was not there. All right, man. In annexure 4 is the inquiry report. I have not put any signature in that signature, but it is stated to be inquiry report. Lord's page 28, annexure 4 series, man. There, but in the statement I have this in the statement.
You signed in the
in the statement I have been.
You have signed at the bottom,
Yes, but inquiry report I am not there. Inquiry report submitted.
Inquiry report is his report.
But
You did not sign. But on your statement you have signed.
But in the statement, well, I have not admitted that I have engaged those students, my lord.
No, you said that you never identified to his farm to the students, but invited them to their village to participate in the village festival. Named Cattle Puja at Bakuragod of his village.
Petitioner has no land, my lord. The fathers of the petitioner,
This is what you are admitting. You say that, but you invited them to their village to participate in the village festival named Cattle Puja at Bhakurgoda. This is your.
Yes, I admit that Bhakurgoda there is a Cattle Puja function, and I had invited the parents through their students that they may attend the festival. only this matter.
Hmm.
But I have not, since I have no agricultural land or cotton field, I have not engaged. They have gone to the Bhakrugoda for attending the function. In the middle, they have inquired the child helpline. And was because the media was there, media covered the matter. In the same day, he was suspended. In the same day, he was disengaged.
No, then 2 days back he informed to them
It is all
he informed to them to engage by their parents, aged members for plucking of cotton. Then he confessed his fault to inform the parents through the students for the purpose.
for the person of a cotton field for to attend the festival, my lord.
It is his admission. Are you
All right. All right. I'll close it. All right. Hearing concluded, judgment reserved. Parties may file their written note of submissions and memo citations, if any, within 3 days. Yes.
Within 7 days, my lord.
Within a week. All right. Now, कौन रहेगा? Sorry, ना? Weekly. Very good. Quickly list item number 64. May I? The petition 23 offense under section 376 to 7 294 323 506. Age of the victim is 19 years. From the FIR as well as the 164 statement, the victim is a consenting party.
Consenting party.
Consenting party. Why you are saying consenting? Last melon, last page. Last page. Did not disclose before anybody. Their lordships, so my instruction counsel lordships, in 8 cases, this petitioner has been convicted, and in appeal, he has been released on bail by this honorable court. And 1 case he has been acquitted, and 2 cases is under, including this case lordships, another 1 case, both are under trial lordships. In this case, out of this case, out of 17 witnesses, 4 witnesses has been examined, including IO lordships. And your lordships, it is alleged that this petitioner is a branch manager lordships. In fact, if lordships will see the statement of evidence of the informant lordships, that is PW2 at running page 55. Yes. Their lordships find on page 56. Sorry, your lordships. There are lots of 57 lordships, kindly see. Page 57. Yes. It is 3rd paragraph. I have not received any dividend from the accused company. It is a fact that as per the share certificates, I am entitled for receiving a dividend into not interest
in test. It is not a fact that there is share certificate value is matured up to 21 years, but not 1 year. I have deposited a share certificate which is branch office of the company, but with whom I cannot say name of the employee of the company with whom I deposited. I have handed over the share certificate to the brother of the Suresh Chandra Padi, this present accused is saying, who was present in the office at that time. I have not deposited other two share certificates as I was not available at Barampur. It is a fact that when I made a written claim to the redemption of share of the accused, GB Goal issued checks for share value of to me at Barampur office. But when I cannot say the exact date of issue of check, I cannot say the exact case number, that is NI Act case filed under section 138 NI Act. In that case, the accused GB Goel was punished. I have not filed any judgment copy to the said NI Act case. The amount involved in this case was in NI Act are similar. I have not deposited any amount for my wife. Rather, she has deposited herself. So, Your Lordships, and Your Lordships, in the statement of evidence of the IO, that is page 65, Your Lordships can see.
Yes.
There is the IO evidence. Page 65, the signature of the accused Suresh Chandra Padi were not there in the seized share certificates. And Your Lordships, paragraph 22 on the same page, last line. I have not verified any document to show the Suresh Chandra Padi was the branch manager of the Barampur branch of the accused company, Your Lordships. And in this case, complaint has deposited, as per his allegation, complaint has deposited 3 lakhs and his wife has deposited 12 point something. And they have been in the NI case, he has not, this petition has not been added as accused because signatory is the GB Goel, the company's director. So in no way he is concerned to this case, Your Lordships, in this case. And petitioner is in custody since, in this case, remanded in the custody on 23/7/2021. Though he has been similar type of cases, he has been same company. He has been custody since 26/8/2013, Your Lordships.
Yes, Mr. Bhuya.
Your Lordship has seen, I have the copy of all the depositions, and all the witnesses have unequivocally stated that they have handed over the amount to this S party, who is the petitioner in the present case. He was working as branch manager of Barampur branch. That is all the statement of all the witnesses, Milord. All the 4 witnesses have stated so, Milord, that he was the branch manager and they have handed over the money to this person. Apart from this, as my learned friend has pointed out, there are 19 cases of similar nature has been initiated against him. Some of the cases he has been convicted and he has preferred appeal, Milord. So the prima facie, the conduct of the petitioner reveals, Milord, that he is involved in similar commission of similar type of offences. And Milord, money collected is more than 5 crores, Milord. And the total persons were defrauded is 155 persons in the present case. So,
Mr. Das.
Your Lordships, in this case, there's no involvement of this petition.
You have read out the depositions and read the deposition. Again, you will say there's no, a little bit, those depositions.
He has deposited the money with the company. Deposited money with the company, Your Lord.
I deposited my money at branch office of Barampur and Suresh Chandra Padi. You are Suresh Chandra Padi.
I am Suresh.
Have issued receipts in favor of my deposits. They have issued 10 receipts for my deposits out of the total receipts. Voila. Next देखिए.
But I said, Your Lordships, there is no signature is there, Lordships.
There may not be signature. There may not be signature. Somebody else of the company may have signed and you may have handed over.
And your lordships, I'm coming, your lordships. It is.
The accused persons are approached me personally to deposit in their company. Being allured, I deposited rupees 3 lakhs with the company. I deposited the money in the Parampur branch office. They have issued 3 bonds.
That is, your lordships perusing the PW1 statement.
PW1, the
PW1 is not the complaint here, lordships.
No, he's not the complaint. I know.
Lordships.
I handed over the checks to Suresh Chandra Padi, branch manager. Suresh Chandra Padi issued 3 numbers of share certificates after 10 days of my deposit. This is in cross examination. All right. That's all.
This custody since your lordships 2021, your lordships.
Since when?
2021 in this case.
7-21.
In fact, it's all are the similar complaint case.
No, I will look into this case. I will not look at the antecedents. Normally, I never look at the antecedents, but this is an economic offense.
Yes, that
This is an economic offense. Very seriously, 150 people are involved. More than 5 crores is, and there is prima facie evidence. It is not that there is no evidence. The petitioner is in custody since 23/7/2021 in connection with such and such case. It is alleged that the petitioner, in association with several other persons, collected deposits from the local public on the promise of giving them higher returns. Stop. In the process, more than 5 crores appears to have been collected from more than 150 persons. All these persons have been cheated. The trial has already commenced with several witnesses being examined. Copies of the depositions of the said witnesses enclosed to the bail application reveals that there is prima facie evidence to show the involvement of the petitioner, in as much as the witnesses have stated about handing over money to the petitioner, who also issued receipts and share certificates to them. Stop. It is argued by Sri A.K. Das, learned counsel for the petitioner, that the share certificates or receipts do not bear the signatures of the petitioner, nor there is any evidence to show that he was working as branch manager in the Parampur office. It is further submitted that the petitioner has been in custody for nearly 3 years, and therefore lenient view should be taken. Parat. Sri Vivekananda Bhuya, learned counsel, appearing for the state in OPID matters, submits that the petitioner is a habitual offender, being involved in as many as 19 cases, and has also been convicted in some of them. So, there is clear evidence in the present case of his involvement to the extent of receiving money as branch manager from the informant and several other persons. After considering the other submissions and on going through the materials available on record, including the case diary and copies of depositions of the 4 witnesses examined so far, this court prima facie finds evidence of involvement of the petitioner in the alleged occurrence. Since it is an economic offense having wide ramifications and several other witnesses remain to be examined, it would not be proper to release the petitioner on bail at this stage. The bail application is therefore rejected.
Your lordships, in fact, he has 11 number of cases, not 19.
11 कर दूं तो 19 में 11 कर दूं. ये बंद करो.
Charge sheet has been submitted under section 376 2N 417 of IPC, my lord. The petitioner is custody since 25/7/2023. And as per my
audio 161 almost same malad I have
Same.
folded. आगे ତାପରେ ସେ ମତେ ସାଇକେଲରେ ବସେଇ ବହୁତ
Here I am in custody since 23/6/2023.
23/6?
2023.
Yes.
The incident happened on 21/6/2023.
Yes.
I am the husband, Milos. The parents of the deceased had come to visit our house, and after they left, the deceased slipped from the stairs, sustained injuries, and died. I informed the parents. They came and they lost the FIR. And in the FIR, they say, your lordship will look at the FIR. That ବିବାହ ପରେ 2-3 ମାସ ଚଳିବା ପରେ ଶ୍ୱଶୁର ଘରେ ଟିକେ ଟିକେ ଛୋଟ ଛୋଟ କଥାରେ ମୋ ଝିଅ ଉପରେ ତା ସ୍ୱାମୀ ଶାଶୁ ସୁଚିତ୍ରା ଘର ପାଖରେ ସୋନି ନାମକ ଝିଅ ହଇରାଣ ହରକତ କଲେ. And then they say, next page my lords may see, ଆଲୋକ ସୋନି ସହ ଖରାପ ସମ୍ପର୍କ ଥିବାରୁ ତାଙ୍କ ବାପା ଜାଣିବା ପରେ ଏବଂ ଝିଅ ଖରାପ ସମ୍ପର୍କକୁ ବିରୋଧ କରିବାରେ ସେମାନେ ନ ବୁଝିବାରୁ ତାଙ୍କ ବାପା ଆତ୍ମହତ୍ୟା କରିଥିଲେ. My father had committed suicide. So this is the ground they say why he committed suicide. କେତେ ଥର ସ୍ୱାମୀ ଶାଶୁ ଓ ସୋନି ମିଶି ମାଡ଼ ମାରିବାର ମୋ ଝିଅ କ୍ଷତାକ୍ତ ହୁଏ. ଗତ ମାସକ ତଳେ ମୁଁ ନିଜେ ଯାଇ ବୁଝାସୁଝା କରିଥିଲୁ. ସକାଳେ ମୁଁ ମୋ ସ୍ତ୍ରୀ ତାଙ୍କ ଘରକୁ ଯାଇଥିଲି. ଝିଅ ଆମ ଆଗରେ ବହୁତ କାନ୍ଦିଥିଲା. ଆମେ ତାକୁ ବୁଝାସୁଝା କରି ଆସି ଘରେ ପହଞ୍ଚିବା ପରେ ଫୋନ ଆସିଲା, ତମ ଝିଅ ଦେହ ସିରିୟସ, ଜଲ୍ଦି ଆସ. ଆମେ ଦେଖିଲୁ ଝିଅ ପିପିଲି ହସ୍ପିଟାଲରେ ମୃତ ଅବସ୍ଥାରେ ପଡିଛି. ମୁଣ୍ଡର ପଛପଟେ ଓ ମୁହଁ ଏବଂ ସାରା ଶରୀରରେ କ୍ଷତ ଚିହ୍ନ ଅଛି. Now, investigation in the charge sheet, my lords, the IO has found no connection of the mother-in-law and did not submit a charge sheet against her. And as regards that relationship with Sony also, nothing was found, and she has also not been named in the charge sheet. And because the petitioner was there in the house, that is the only reason, my lords, he has been implicated in the charge sheet. Now, if your lordship will look at the postmortem report.
Postmortem report? Yes, ma'am.
Postmortem report reveals
14 injuries.
14 injuries.
And injury matter.
And more players for the I am placing every. Yes. So don't worry. Contusion size 8 cm into 4 cm over the left parietal eminence.
First,
column 6, my lord.
Column 6, yes.
Contusion 8 into 4 cm present over left parietal eminence. Then next injury is a contusion 7 into 5 cm present over right parietal eminence. Abrasions 2 cm into 2 cm over the right ear pinna lobule. 1 cm into 5 cm on the right molar eminence of face. Abrasion of sizes 1.5 cm into 0.5 cm present over right and mid part of upper lip of mouth. Bruise of size 2 cm into 2 cm over right and mid part of inner side of upper lip of mouth. Abrasion sizes 0.5 into 0.5 cm, right side of lower lip of mouth. Bruise of size 1 cm into 1 cm present over right side inner aspect lower lip of mouth. Abraded contusion 2 into 3 cm over right angle of jaw with surrounding contusion 15 into 10 cm. contusion of 7 into 4 cm present over right side front of neck, 5 cm below right angle of mandible. Contusion 5 into 2 cm present on left jawline 2 cm below this chin. Abraded contusion sizes 15 into 5 cm present over upper aspect of front of chest from left infraclavicular area to right infraclavicular horizontally with a surrounding contusion 34 into 15 cm. Bruise 1 cm into 5 cm over dorsum of right wrist. 3 crescent shaped abraded contusions size 0.35 cm into 0.15 cm over front of the chin, 1 cm below the lower border of the right side of the lower lip of the mouth, 1 cm apart to each other. 2 numbers of crescent shaped abraded contusions, 0.35 cm into 0.15 cm present over the left side of the nasal bridge. Internal injuries, under surface of the scalp is contused throughout, thick subscalpal hematoma collection, both side temporalis muscle found contused, skull intact, dura tense and bluish, diffuse subarachnoid hemorrhage present all over the brain. Rest of the brain intact and pale. Soft tissues underneath the right side of jaw, strap muscles of right side of neck are contused, hyoid and other neck cartilages are intact. Your Lordship may note this. Mucosa of larynx and trachea are hemorrhagic. Left side rib cage contused, 2nd to 8th intercostal space. Left side 4th rib fractured, my lords. Now, I'll ask your Lordship to also kindly look at the external appearances, column 1, my lords, of the postmortem report.
Yes.
Condition of subject and complexion, fair body build, average body length 166 cm, scalp hair, black cuff length 30 cm, face congested, eyes open, conjunctiva deeply congested, cornea hazy. Doesn't say that there is any cyanosis found on the face. Now, taking into account, my lords, the 2 injuries found on the lip, my lords, the opinion of the doctor is that death is due to asphyxia as a result of smothering and violent compression of the neck when the hyoid bone is intact. How he comes to that conclusion, only he can say when he goes to the witness stand. But these are the injuries. Admitted case, my lords, of the prosecution is that the deceased was found near the stairs, my lords, leading to the roof. When the mother was absent in the school, the mother was named as an accused. The neighbor's daughter, who is studying outside, my lords, she was also named as an accused. The investigating officer found no materials to implicate them. But merely because I was there in the house, I am implicated with these injuries. Had there been assault, my submission, why should there be only contusions and abrasions? And there is no evidence whatsoever, my lords, to show that soon before that death, there was any demand limits. And the spot map also, your lordship will see, that also supports, my lords, the prosecution, the case of the defense that the deceased fell from the stairs. The spot map also reveals that inside the veranda, my lords, blood patches and others were found. And if these are the injuries, my lords, are abrasions, bruises and contusions, my lords, where is the question of blood coming out?
No, you come to the opinion.
Yes.
At serial number 2. One is also there, but 2.
External injuries number 4 to the external injuries number 7, along with external injuries number 13 to 14, 13 and 14, with corresponding internal injuries, suggestive of forceful closure of external airway manually, while external injuries 8 and 9 with corresponding internal injuries suggestive of compression of the neck. Now, your lordship may see what are those injuries. Injuries 4 to 7, my lords. 4 is abrasion 1.5 cm into 0.5 cm over the right mid part of the upper lip of the mouth. There is an abrasion here. Bruise over the right mid part of the inner side of the upper lip of the mouth. There is another abrasion inside the mouth. Then 7 is a bruise 1 cm into 1 cm over the right side of the inner aspect of the lower lip of the mouth. Somewhere here, my lords. And the 7th injury is a bruise over the right side inner aspect of lower lip of the mouth. How can they be suggestive of abrasion? The face would have been cyanosed, it would have been blue all over the jawline, my lords. Why should the jawline be contused?
Have you gone through any medical jurisprudence?
No, madam.
You should.
I will. You should. Yes, madam. Give me some
If
time.
you want to support this postmortem report or the cause of death as certified by the doctor, then the prima facie, because and the hyoid bone was not fractured, it is intact. So that is, these are some of the things that you must consider. You can look into Modi's, yes, threat of contusion. Whether contusion, he has raised some pertinent points. Have you taken note? And please answer it.
Yes. Item 68.
Whether the court will accept it or not is a different matter, but let us make some research.
Yes.
May I please, Your Honor?
68.
Madam, the case is under section 370 of the
370.
madam,
Yes.
item 68, madam.
Huh.
370 of the Indian Penal Code, madam. And he is in custody since 21/10/2023. And allegation in
You are the labor sardar or what?
Madam, allegation.
Driver disclosed that the present petitioner taking those 45 persons to Hyderabad.
He was not present at the spot.
No, he was.
No, what was his role?
They have already permit, madam, and they are regularly taking.
No, what is his role according to
At
the
that point of time, he has no labor license, madam.
All right. The petitioner is in custody since
2/10/2023.
2/10/2022, 23. In connection with such and such case, it is alleged that the petitioner, without having any labor license, was illegally transporting as many as 45 laborers from Odisha to
Andhra
Andhra Pradesh. In a truck or what?
Bus,
In a bus. As it appears, the petitioner was not present at the spot, but has been implicated on the statement of the driver of the bus. Stop. That apart, it is submitted that the petitioner does possess, does have a labor license. Take into consideration the submissions as above and the period of detention in custody. I am inclined to allow the proof. Let the petitioner be released.
Obligers.
69.
69 after vacation.
After vacation, very good.
Item 70.
Least when moved kar do bagi. Least when moved.
Obligers.
Item 70.
70, there are 2 matters.
2 matters. Achha, we think okay.
We think it. His matter is first. We are brothers. That is here also, there also. Now, my lord, the allegation is that we persuaded certain people to make some deposit in order to make some gain, quick gain. So we disclosed a app that his name is APM app.
Is it not a OPID matter?
No, sir.
No.
It has crime branch nahi thala.
Achha.
Crime branch has filed its charge sheet already since
That you
7/12/2023.
APM app.
APM app. ସେଥିରେ ଟଙ୍କା deposit କଲେ 5 times କି 4 times କଣ ହବ ବୋଲି ଲେଖିଛନ୍ତି. Anyway, my lord. Now,
I'm sorry, my lord, I have marked.
mark ଟଙ୍କା ଦେଖିବେ କେମିତି?
Charge sheet, my lord, whisper, my lord. Charge sheet, my lord, whisper, my lord. How much money, where they deposited, how they deposited, what is the amount, my lord. Besides that, my lord, my 2 accounts have been seized. Nothing has been trailed, my lord. Nothing has been deposited.
Yes.
Last instruction, my lord.
They are 2 brothers. They are convening the meeting to allure the general public, my lord, who are depositing, and they are receiving 3% interest, the amount deposited by the downline investors. And in the account of Arun Kumar Das, it is ascertained that cash of 17,91,884 has been deposited by 100 of victims. And so far as Hon'Ble Kumar Das, 4,70,125 has been deposited by several customers for investment.
Has the amount been secured?
Not, it has been
କୋଉଠୁ ଦେଖିକି କହୁଛନ୍ତି ଆମ ଚାର୍ଜସିଟ ତ ଆମେ ବି ଦେଖୁଛୁ
investigation of
ଇନଭେଷ୍ଟିଗେସନ ଟା ଆଗ ନା ଚାର୍ଜସିଟ ଟା ଆଗ ସାର୍ ଦେଖୁନାହାନ୍ତି ଆପଣ
IR ଯାହା
we are holding he might instruct you that we are holding the charge sheet which has been filed.
Charge sheet has been submitted.
Let them deposit some amount. Huge amount is there. 17 lakhs.
ଆମକୁ ନାହିଁ କୋଉଠି ଚାର୍ଜ ସିଟ ରେ କହିନାହାନ୍ତି ସାର୍ କୋଉଠୁ କହିନାହାନ୍ତି ଦେଖନ୍ତୁ you don't have the charge sheet, kindly go through this. ଅକ୍ଟୋବର ରୁ ଅଛି ସାର୍
Well, it will impose stringent conditions.
Yes.
ମୁଁ ବୋଧେ ଭୁବନେଶ୍ୱରରେ କାମ କରେ ନା କଣ କରୁଥିଲି
The petitioners are in custody since 12/10/2023 in connection with such and such case. It is alleged that both the petitioners created a mobile app called
ଆମେ ସାର୍ କ୍ରିଏଟ କରୁନୁ ଆମେ ଗୋଟେ ଏଟିଏମ ଆପ ରେ ଡିପୋଜିଟ କର ବୋଲି ତାକୁ ପରସୁଏଡ କଲୁ
अच्छा ହେଲା
ଯାହାର ହେଡ ସେ ଯୋଉ କହିଲା ଫାକୋ
the petitioners lured several people to invest in an app called APM on the promise of very high returns within a short period of time. Accordingly, the informant and several other persons have deposited substantial amounts, being convinced by the petitioners. The petitioners convinced the depositors by holding several meetings. But suddenly, the app became defunct on 3/10/2023. The case was therefore registered against the petitioners. It is submitted that charge sheet having been submitted, there is no whisper of the amount allegedly transferred to the account of the petitioners. Then State Council submits on instructions that huge amount has been transferred to the account of the petitioners, even though the same has not been mentioned in the charge sheet. Be that as it may, after considering the above submissions and on going through the materials on record, including the charge sheet, this court is of the view that since charge sheet has already been submitted, no useful purpose would be served by detaining the petitioners in custody any longer. The bail applications are therefore allowed. Let the petitioners be released, so and so. Condition Coram 1. They shall deposit their passports, if any, before the court at the time of release. Next, they shall furnish property surety of ₹50 lakhs each to the satisfaction of the court below. They shall not leave the territorial jurisdiction of the court without obtaining leave. Next, they shall personally appear before the court in session over the matter, and no representation through counsel shall be allowed. Yes.
50 lakhs ଟା ଟିକେ ହାର୍ସ
ବହୁତ କମି ଯାଇଛି
ଦେଇପାରିବ ନ ଦେଇପାରିବ ପୁଣି ଆସିବ ମଡିଫିକେସନ
ପ୍ରପର୍ଟି ସିକ୍ୟୁରିଟି
ଆଜ୍ଞା
ପ୍ରପର୍ଟି ସିକ୍ୟୁରିଟି
ହଁ ସାର୍ ଏତେ ଟଙ୍କାର କଣ ଆସିବ ଆଜିକାଲି ଭ୍ୟାଲୁଏସନ ହେଇକି ଦଉଛି ନହେଲେ ଭୁବନେଶ୍ୱର ଆରେଷ୍ଟ ହେଇଗଲାଣି 3 ଜଣ ବେଲର ସେ ଫେର ଧର ଆସିବ ଗୋଟେ ମଡିଫିକେସନ
କରିବେ କଣ ମନା କରୁଛି
ଗାଁ ଏ ଜାଗା ତ
ଯେତେ ପଇସା ନେଇଛନ୍ତି ସେଥିରେ ହଉ ତାଙ୍କୁ କରିଦିଅନ୍ତୁ 30 lakhs କରିଦିଅନ୍ତୁ.
Item 71. Mailorship fees. When the petition is custody, my lord, from 9/9/23, my lord. With the alleged offense, my lord, 414, 420, and other offenses, my lord. The allegation is that, my lord, the present petitioner,
You have neither enclosed the FIR nor the charge sheet, nothing, no document.
the charge sheet we have received, we have obtained that.
FIR,
My lord,
FIR?
FIR we don't have in that time, my lord, when I have filed this. petition.
Now where is that FIR? Now you have.
Also, right now in this charge sheet, my lord. Yes. But the allegation is that impersonating himself as a girl, she has defrauded this amount of 34,37,500. But the actual fact is that, my lord, the informant
Impersonating as a girl?
Yes, my lord.
Well,
It's an
he's a-
allegation, my lord.
He's a boy.
He's a boy, my lord. My lord, both are played a Dream 11 game. Since he's an officer in NTPC, he had deposited in his account the money. And when they lose that huge money of 34 lakh, then FIR was lodged, my lord. This is the, my lord, actual fact. The observation may kindly be seen in page 11 of my FIR. Page 11, may kindly.
फेसबुक रे ସାଙ୍ଗ ହେଲେ ସେ ତାଙ୍କୁ କହିଲେ ଯେ ମୋ ବାପାଙ୍କ ଟଙ୍କା ପଠା ଇଏ 34 ଲକ୍ଷ ଟଙ୍କା
Profile de
34 ଲକ୍ଷ ଟଙ୍କା ଇଏ ଆଣିଲେ କୋଉଠୁ ସେଇଟା ବୁଝିବା କଥା। ଦେଖିଲା ବେଳକୁ ସେ ବିଲକୁଲ ଝିଅ ନୁହଁ, ସେ ଜଣେ ପୁରୁଷ। ଭଲ ମୁଁ ଝିଅର ଫଟୋରେ ଲଗେଇଦେଲେ।
Even WhatsApp ରେ my lord transfer is the number हरके।
ଟଙ୍କା ଫେରାନ୍ତୁ।
My lord, both this played, they played Dream 11 ने पैसा पड़ेगा।
in two accounts.
हाँ।
In one account 10,37,000 and another account 23,60,000.
And has it been secured? Has it been
That
frozen?
instruction I don't have, my lord. But
My present petition is concerned, he just expecting the competitive examination.
Is
ଗୋଟେ competitive examination prepare କରିବା ପାଇଁ ଭୁବନେଶ୍ୱରରେ ପାଠ ପଢୁଥିଲେ। Dream 11 ଖେଳିକିରି
ଏଇ competition ତ ଏଇ competitive exam ଆଉ।
Both are, my lord,
What is the amount taken by him?
my lord, in two accounts, one is 10,37,000 and another 23,60,000.
So 33 lakhs. 34 lakhs.
34 lakhs.
Total, my lord, 34 lakh 37,000.
So that amount, where is that amount now? Whether it is secured or
That if you let me tomorrow, next week I will. Whether that account has been
it is submitted by London State Council that as per investigation, a sum of nearly 34 lakhs was credited to the transferred to the petitioner's account. Leave this matter next week. London State Council shall inform the court whether such amount has been secured or not. Yes.
Item 72, oblige, my lord.
Yes, item 72.
Lord, I am on VC, my lord. I am permitted to have.
Yes, yes.
Take my submission. This the petitioner is in custody since that is on. Hello, sir. Am I audible, man?
Yes, yes, yes.
Sir. The petitioner is in custody, Lord, on the allegation that he is not named in the FIR. The victim doesn't name the FIR.
But Mr. Murthy, I don't have the FIR. That is the problem.
No, my lord. I have. Your lordship, your lordship may kindly.
3 is there. So
No allegation against him. No allegation. Running page number 12 may kindly be seen.
Running page number
12. That is the FIR, annexure 1.
Okay.
Now, the mother has lodged an allegation that the daughter is missing. So there
notice has to be served. Notice has to be served.
Well, this is 376(3) matter, so notice has to go.
My humble submission is, Lord, there are no allegation against him about a commission of rape. He is the manager of a lodge, and as against him, only the allegation is PITA, that he allowed 2 persons to go into the lodge. That's all, without making an entry in the register.
No, but I think the allegation is against allegation against you is of 376(3).
She
So
has already
technically,
no allegation against him. So against him, there are the two witness, victim as well as the mother, both have been examined and in the court. their testimony. I have uploaded it on 6/4/24, and they have no grievance against the present petitioner. I am permitted to read. I cannot say
Deposition
the name of-
upload করছেন because you have uploaded those depositions.
Yes, my lord, two. On 6/4/24.
They are not on record.
I cannot say the name and location of the lodge where I was shifted. The lodge has not been identified. Simply, I do not know the accused Ramakrishna Patar, the present petitioner, present in the dock. For the first time, I see him in the court. Then the mother has always been examined. The mother.
No, we'll take it up next week because the depositions from which you are reading are not there on record.
Yes, my
You
lord.
claim to have uploaded them
Sure, my
on the
lord.
court's website.
From the virtual court, Jaipur, madam.
So
I also don't have.
Shri T. N. Murthy, learned counsel appearing for the petitioner submits that he has uploaded the copies of depositions of the victim
And the mother.
And the mother.
virtually,
And the mo- And the mother also.
and the victim and her mother.
Mother. Both have
That
been.
is to verify and tag the copies of the depositions to the case record. Let this matter next week. Let it come next week. Along with that, we will see.
Yes.
If there is no allegation of 376(3) against you, then notice will need not be issued. I can consider your
No allegation.
yes.
No allegation.
All right.
Oblige.
May I please lordship.
Item 73.
Praying for after vacation.
Yes.
Item 73, praying for after vacation.
Leave this matter after vacation.
Item
This is a matter when moved.
Item 74.
Blessing.
74.
May I please, your lordship? My lord, petitioner is in custody since 12/11/2023. Initially, FIR was registered under section 498, 302, 304B, 34 IPC, read with section 4 of DPI. But it turned to later on charge sheet submitted on 498, 304B, 306. 306. Allegation in the FIR that the petitioner want to go to Himachal Pradesh for work. There was a disturbance between the husband and wife, and thereafter she commits suicide. PM report reveals suicidal hanging. Door was locked from inside. Later on, when the petitioner came from by purchasing railway ticket, he found from a hole that the wife committed suicide.
Yes.
Yes, my lord. After 4 and 4.5 months of marriage, incident occurred, my lord. Petitioner is a husband and admittedly charge sheet filed under section 306, my lord. And so far as the PM is concerned, cause of death is asphyxia and venous congestion, and nature of death is suicidal hanging. And there was a informant and the other witnesses, independent witness, they say that there was a quarrel between the husband and wife. Every time there was a quarrel. And there is no demand of dowry or else, my lord. This is the material, my lord.
But there's another significant thing is that the door was locked from inside.
Yes, that is there, my lord.
The petitioner
One hatched house.
Custody since 12/11/2023.
12/11/2023 in connection with such and such.
The independent witness said so.
It is alleged that the petitioner, being the husband of the deceased, subjected her to cruelty and also killed her. In course of investigation, however, the case turned after completion of investigation. However, charge sheet was submitted under section 306 of IPC and other allied offences. Since it was found that the deceased had committed suicide. Learned counsel for the petitioner submits that the deceased had committed suicide by bolting the door of her room from inside. And the husband was not present at the relevant time at home. Then State Council submits that there is evidence that the petitioner and his wife had frequent quarrels for which the deceased committed suicide, being depressed. Considering the rival submissions and the materials on record, and taking particular note of the fact that the petitioner, that the deceased had committed suicide in her own room after bolting the door from inside, I am inclined to allow the prayer for bail. Let the petition be released.
Obliged.
Item 75.
This case is, the original case is already disposed of by the London lower court, my lord, according to the accused, a person.
Yes, yes.
The case is already disposed of
Okay.
by London lower court.
All right. Dismissed as infructuous.
Item 76.
Please, your lordship. I am in custody since 6th of July. And charge sheet has been filed on 1st November. The petitioner is implicated, my lords, on the basis of a video footage, my lords, which showed him being present and he was identified in the video footage. The FIR is on 36/2023 by the son of the deceased. And his FIR is to the effect that his father is a taxi driver who used to operate a taxi from the College Square taxi stand. And that on 24th of June in the evening, he had been hired by 2 persons and a lady for being dropped at Jajpur Road. But the mobile phone could not be contacted, my lords, after the 12 o'clock on the next day, my lords. And therefore, the informant as well as the car owner, they checked the toll gate records and found that the vehicle had crossed Contaghar toll gate, my lords, in the night. Thereafter, my lords, an information was given at Malgodown PS. And on 28th, message was received that a dead body was found in Ghosipur Thana area, my lords. And the body was identified there.
What is the basis of your implication?
Your lordship may see what they write in the charge sheet is.
Charge sheet, I don't have a copy if you can.
Man,
Then.
your CCTV footage of that College Square taxi stand.
That
they
court
were,
that I was there.
Identified, and after 4 days of the incident, that
Almost like a last scene theory.
Yes.
Almost.
almost, and the disclosure and confessional statement.
Is there any evidence of prior quarrel?
No, nothing. Only regarding that fair dispute. Etik paisa de na mu etik nebi.
What was the cause of death?
Taku gote chunri se jhiyo, one lady was there along with this petitioner. Her chunri re taku chipi ki madala. They assaulted with fist blow and kicks thereafter.
But why will they kill that man?
Only because of that fair. Magila.
That is only on the basis of confessional
statement. 13 na 15 ne bhi segal na 25.
The petitioner is in custody since
6/7/2020.
6/7/2023 in connection with such and such case. It is alleged that the petitioner, the prosecution case is that 2 persons, one of them being a lady.
3 persons.
3 persons.
2 men, 1
Agent
lady.
petitioner and 2 others.
3 persons including
a lady,
the petitioner and a lady, had a taxi being driven by the
deceased
father of the informant. Stop. Subsequently, there was no information about the whereabouts of the taxi driver. On the next day, it was found, the dead body of the deceased was found lying within the jurisdiction of the Ghosipura police station. The informant being called, went to the spot and identified the dead body, which was of his father. On the basis of CCTV footage of the
Taxi stand.
taxi stand at Malgadam,
College Square.
or College Square, it was found that it was revealed that the petitioner and the other two persons had hired the taxi. Being taken to custody, the petitioner confessed of having killed the deceased, as there was a dispute relating to the fare. Even except the confessional statement while in police custody, there is no other material, there is no other admissible evidence to show the complicity of the petitioner in the alleged occurrence. Considering the above facts, I am inclined to allow the prayer for bail. Let the petitioner be released. Each day appearance in the court without representation. Yes.
Item 77. 77 or 2 weeks after.
Yes.
2 weeks after.
List one moved.
Right.
Yes. Kichu abo na kai.
Item 78.
Kitna matter?
In this case, the prisoner has been charged for offense under section 341, 307, 326 IBC. That the prisoner is in custody since 13th of August 2023. The allegation is that
the injury report?
Injury report, dying declaration is there.
Oh, say 302.
Stab injury, yes, my lord. Stab injury, that is grievous. And
page 35, my lord.
Page 43.
Page 35.
My lord.
There is no page 35. Yeah, the brief ends at page 15. And Nasuda written with outside Guadalpada on the way near Kudopuli and Samlesari parked his truck at Samlesari. And Dinesh Rai driver of truck by keeping previous and you are Dinesh Rai?
Yes, man.
Yes.
Yes.
Dying declaration recorded. In front of magistrate is there.
Dying declaration
marla Dinesh Rai. Kouthre marla Chakure.
The direct evidence is your
मतलब 9 मास लाने भीतर
Mr. Panda ऐसे जीवन सारा रहो
से भी better condition है
No. The petitioner is in custody since in connection with such and such case. It is alleged that the petitioner, because of previous enmity, stabbed the deceased by means of a knife, causing his death. It is submitted that the petitioner has been falsely implicated. Learned State Counsel, while opposing the prayer for bail, produces the case diary which contains the dying declaration of the deceased.
Seizure of knife also from
established. The deceased stated the name of the petitioner as having stabbed him by means of a knife. Stop. The knife was also recovered from his possession. Knife was also recovered. 27 achi.
Yes,
recovered at his instance. Considering the above fact, considering the above, which reveal strong prima facie case against the petitioner, I am not inclined to allow the prayer for bail. The bail application is therefore rejected. Yes.
79.
79, my lord. Though the petitioner is outsider, my lord, but here, my lord, I have a case, man. It is a excise case, my lord. And the threshold your lordship may kindly have perused. There are only independent. One,
Mr. Panda, you certainly have a case. Otherwise, why would you file a case?
No, I have a good.
Without a case, you will never have filed a case.
I have a good case, man.
But the case will be decided whether a court has a case or not.
My lord, for that reason,
And I think the court doesn't have a case.
I am trying, my lord.
You please try. Please try.
Here, my lord, the petitioner along with two others were traveling in a car. In a public place, my lord, in a private car, they are traveling. Thereafter, my lord, the excise department signal to stop, they are put a signal on search with a one independent witness, my lord. They found the contraband of 51 kg. Thereafter, they have tried to comply with section 50 and they ask, they know the ODI. The present petitioner know the ODI. Understand and read and everything. That is written in the PR. Thereafter, my lord, without complying section 50, my lord, they have forwarded. Section 50, my lord, said in a private car, my lord, they have to bow down to comply section 50 in view of Bhutta Singh judgment, my lord. Thereafter, my lord, your lordship may kindly have glanced section 50 clause 5. No, section 50 clause 5 say, my lord. May I read, my lord? When an officer duly authorized under section 42 has reason to believe that it is not possible to take the person to be searched to nearest gazetted officer or magistrate without the possibility of the person to be sought parting with possession of any narcotic drugs or psychotropic substance or controlled substance or article or document, he may, instead of taking such person to the nearest gazetted magistrate or officer, proceed to search the person as provided section 100 of the CRP. Here, my lord, section 100 has not been completed. Kindly have glanced section 100 clause 4, my lord. There shall be most 2 or more persons. In this case, my lord, they have procured only one independent witness. So the seizure, my lord, is a doubtful, my lord. Whether the contraband, thereafter no brasil, etc. are there.
Very good case for trial.
Yes. Acquitted.
Very good case.
Only 3 witnesses, my lord.
Yes, that is what I'm saying. You have got a really very good case. Now I appreciate why you said that you have a case.
Your lordship, I have another submission.
Yes, please.
So he knows the ODI in view of other state, my lord. Your lordship may kindly give me 2-month interim bail and he will not leave the jurisdiction of Samarpur. Another prayer, my lord. If he leaves the jurisdiction,
then what will you do if he goes away? Then what? Then
but it is the mandate, my lord, of the law, my lord. My lord, here, my lord, another prayer. Another state person cannot travel in another state, my lord.
No, he can. I am not saying that I will not.
For that reason, law is here, my lord.
Yes, yes.
They have to mandate this, my lord. Otherwise, my lord, पैसा दे 20 किलो कर भी नहले 50 किलो कर दे मे बी out of court attention record. Your lordship kindly consider the duration of custody period.
The law knows no kindness, no compassion, no mercy.
For that reason, law is there, my lord.
Law is only there for justice. And I find 51 kgs, which is more
for
than
that reason, there is a possibility, reasonable doubt that the petitioner traveling with contraband ganja.
तो समय हो जाए कौन करे समय है गलने छड़ा
था वो एडजन था
list when moved
my lord obliged.
I don't know if
Obliged.
My lord, I am in VC mode. Your lordship may allow me in VC mode.
Yes.
My lord, the petitioner is in custody since 1910-23 and has been charge sheeted under section 420, 506, 34 and 406 of the Indian Penal Code. My lord, the allegation is that
who are you? Yes. What is the allegation?
my lord,
That's
I
how
have
those
been
paid.
charge sheeted under 420, 506, 34
I don't have the case diary, my lord. You can 20 lakhs to provide a medical seat in
This is not
STP medical.
this is not an economic offense. A private party. तमे दबो 20 लाख टका कोन पे दबो? Recently I have held. Today I think I have passed that judgment. No.
Yes.
Today you have
Yes,
filed.
today.
It's a private dispute. Private dispute. And is it an enforceable contract? I am paying you 20 lakhs so that you will arrange a job for me, or this is a medical seat, isn't it?
Medical seat.
Nothing. And the court below holds that Y.S. Jagan Mohan Reddy, how is it applicable? Is it an economic offense or a purely private offense? A private, private dispute. Go to the civil court, recover the amount.
Account transfer phone pay karchi some amount you can secure my
I will say
20
something.
lakhs. Yes, my lord.
20 lakhs neji property surety kar do.
आगे
The petitioner is in custody since
my lord
Yes.
1910-23
1910-2023 in connection with such and such case. It is alleged that the petitioner convinced the informant to pay rupees 20 lakhs
20 lakhs
20 lakhs on the pretext of providing arranging a seat for admission of his daughter in Con Medical College.
SCB Medical College
In SCB Medical College. Bhalo. The informant is said to have transferred the amount in different phases electronically and also by cash. It is submitted that the prosecution case, even accepted on face value, does not reveal a criminal offense. And in any case, it's civil in nature. Stop. Since the contract between the petitioner and the informant, if at all, is an unenforceable one, the petitioner, the informant has filed this, has logged the FIR only as a means of recovery of the amount allegedly paid by him. Then its state counsel submits that the amount being huge and there being a possibility of the petitioner not attending the trial, stringent conditions may be imposed. Taking into consideration all the above facts, and in particular, the nature of the contract between the petitioner and the informant, I am inclined to allow the prayer for bail. Charge sheet has been submitted.
yes my lord yes my lord.
Particularly, as also taking note of the fact that charge sheet has already been submitted. Let the petitioner be released on such and such conditions, subject to furnishing property surety of 20 lakhs. Yes.
Grateful.
May I please, Your Honor? The petitioner has been arrested for offense 394, my lord. Subsequently, charge sheet submitted as 395. Petitioner is a young boy of 19 years who is studying, and it is alleged that he took the lift from the informant, and thereafter, while at the time of dropping, there are the friends of the petitioner who took him to the one room and forced him to keep sexual relationship. Thereafter, there was prior to it, all these three, the CCL, Sunil, two co-accused persons who have a friend, and they have in a Grindr, GRINDR, a gay chat application is there, through which they have in contact with these persons. And actual background that they after the sexual relationship, they forced them to pay the amount. At that time, it is alleged that one
charge sheet has been submitted.
Charge sheet submitted.
Yes, my lord. Charge sheet submitted, but he has been identified in the TI parade, my lord. And
having no criminal antecedent.
criminal antecedent
281, 282. Dita case.
Affidavit ଗୋଟେ ଦେଇଛନ୍ତି ସେଥିରେ ଗୋଟେ ଦୁଇଟା
Dita case 281, 282.
3, 4, 5, 6, 7, 8, 9, 10 10ଟା ଦେଇଛନ୍ତି।
Manoj Dor.
ରାହୁଲ ମନୋଜ ରାହୁଲ
Manoj Dor. One case.
You have the case diary?
Yes, madam.
Charge sheet is there.
Answer
No antecedent.
not there, madam.
And the co-accused,
Charge sheet has been submitted under
395.
395.
And the allegation against that Krishna who have transferred that amount, from whom all these amount are
We'll take care of tomorrow. All the remaining matters will be taken up. No, all the remaining matters will be taken up tomorrow as leftover matters. Yes. Passover matters tomorrow. All leftover matters. Yes,
Item 3, not this.
not this.
Item 83, Lord, the cryptocurrency matter. We have sent letter to obtain instruction how much money credited to the account of the.
83.
No, my lord, your lordship has had this matter.
Yes.
On 3 occasions, 4 occasions, they took time.
Yes.
But I am the local person. There is no recovery from the petitioner that any matter in the back and forth, there is nothing. The local.
So let me hear it tomorrow.
Again.
Tomorrow if necessary, I'll grant time.
Charge sheet ହେଇଯାଇଛି।
ବାବା କଣ ହେଲା ସବୁ? 5 ଥର ନେଲେ କଣ ହେଲା ସବୁ? କଣ ଏତେ ବ୍ୟସ୍ତ କାଇଁ ହଉଛନ୍ତି?
ଭିତରେ ଅଛି।
ଭିତରେ ଅଛି ଥାଉ। ମିଛୁଟାରେ ଭିତରେ ଅଛି। ମିଛୁଟାରେ ଭିତରେ ଅଛି ଭଦ୍ରଲୋକଟା କି? ଥିବ ଭିତରେ ଅଛନ୍ତି ଥାଆନ୍ତୁ ଦେଖିବା କଣ ଯଦି necessary. We will always take a balance. If it is necessary, I will grant time. If it is not necessary, I will not grant time.
I only bring for
ସେଇଟା-
next week. जो next week ଆସିଛନ୍ତି ତା ଭିତରେ instruction.
ନାଇଁ
Next week.
ଆଉ ଛୁଟି ତାପରେ ଛୁଟି
Next
ହେଇଯିବ
week ପରା।
next week।
No, if he is saying that next week he'll bring all the records.
ନାଇଁ
So
ଚାର୍ଜ ସିଟ୍ ହେଇସାରିଲାଣି ମୁଁ ଚାର୍ଜ ସିଟ୍ କପି ଅଛି ମୋ ପାଖରେ ଚାର୍ଜ ସିଟ୍ ହେଇସାରିଲାଣି ମୋ ପାଖରେ ଚାର୍ଜ ସିଟ୍
so 7 days more. What will be the?
ମୁଁ ଆଜ୍ଞା କହୁଛି ଯେ ଆପଣ ଯୋଉଟା ଡେଟ୍ ଦେଇଥିଲେ ଯୋଉ ତାରିଖକୁ ଆସିବ ସେଟା ଆସିଲାନି
Yeah, ଅଛି ତ list ରେ ତ ଅଛି. All right. Tomorrow we'll see. Tomorrow we'll see. Tomorrow. Remaining matters को left over करेंगे.